Page number 500.
Lot for extension of
I
interim
would
order.
like to proceed with the case.
My lord, may I pray a leave, my lord?
Monthly list. July 1.
My lord, I have filed a read petition for police in action, my lord. Larnet ACJM Chandannagar passed an order for urgencies, my lord. There is some debts due. In the monthly, I am praying for, my lord, there are some debts due to the secured creditor, my lord. Despite of the direction of the police authority, not executed the order of the Larnet ACJM, my lord. My lord, this is an execution order, my lord.
My lord, ABTA wants to hold a rally from Subodh Malik Square to Rani Rasmani on 30 July, my lord. Made a representation on 23rd July, my lord, for NOC. Till date, the police sit tight about the matter. Then the last occasion, the ABTA made the representation, and the last moment it was cancelled, my lord. It will be kind enough, my lord, 30 July. Coming Thursday. Yes, my lord. Coming Thursday, my lord. So, my lord, keep this matter tomorrow or business of the court permit, my lord. Too much. Great.
Your Lordship, may I be permitted to mention on matter for extension of interim order, Your Lordship. 31st July, the interim order will expire, Your Lordship. Yes, Your Lordship. Your Lordship, the order was passed on. Last order was passed by this court. The original, the interim order passed by the Honorable Justice Rajoshi Bharadwaj, Your Lordship.
My lord, for extension of interim order, my lord.
Yes, Your Lordship. 30th April, Your Lordship has passed. Extend the interim order.
My lord, it is expiring on 31st of July, my lord. It should. And on notice, I have to
Correct. I was agreeing to the statement, but my surname has been changed to Ray today, but this correction was not.
Lord, I am mentioning these three.
1190 Malad in my lord's list. My interim order Malad is Malad had passed the interim order. Yes, Malad at 31st of July. Malad had passed the order Malad on 20th of. Malad is expiring Malad on 31st. Yes. Very good. Very good. Very good.
My lord, mention.
same matter which are appearing in the monthly matter, assigned matter. Assigned matter. Because the matter pertains to the recruitment of upper matter. Can you take the recruitment is going on, my lord?
My lord.
That matter of Shankar Artho petitioner, my lord had given a verbal direction not to hold off our hands. Lordship, the matter was made hearable 29th June. The petitioner till 29th of June, my lord had said that hold off your hands. 29th of June. Thereafter, the matter has not been taken up. Lordship, petition number 2 is already in custody. In another case, for this case, dual interrogation was made. He has been absolutely non-cooperative. Lordship, he takes it up.
My lord, may I be permitted to mention
No, my
My lord, may be permitted to mention the matter of Saturdays. My lord, in that matter, my lord, name of the advocate, state advocates assisting learned AG and GP were not recorded. Name of the advocates assisting learned GP and AG were not recorded. My lord, it is evident because my lord, they are senior counsels. They could not represent the court.
My lord, mentioning for restoration.
My lord, it is
Mention for
evident from
restoration.
we have the screenshot also.
Mentioning for restoration. My lord, no limitation has been filed. When filed 25th, 29th October 2025.
My lord, may I permit to inclusion in this, my lord? Mention, yes, my lord. I am motion, my lord. Yeah, 26, 2026. Yeah, no, it was not hard. I filed it in 19 to 26.
May we
May I be permitted to mention, my lord, these
Madam,
three serious. My lord, may I be permitted to mention these three seriatim matters, my lord, in your lordship's list. The matter appeared on 2nd March as 540, on 6th April as 426, on 4th May, my lord, 400. My lord, my client is without water and electricity. My lord, let the matter, water and electricity, my lord, let the matters be listed so that order can be passed by your. Yes, my lord, I am reading out, my lord. No, my lord, kindly appreciate, my lord. It is going down, my lord, by day, not coming up. My lord.
Content application for violation of the lordship order dated 7th of July 2026. It was filed in the second week of July. It was returned on 21st. 21st of July. Last Friday. Friday is the date for that.
Lordship, may I be Lordship, may I be
I am praying for the inclusion of the list. Lordship, this matter already heard in the year of 2000, in the month of May, Lordship. Lordship have directed that the matter should be came in the month list of July. But Lordship in the no, not
Lordship,
Lordship. Yes.
may I be permitted, Lordship? May I take your Lordship's leave to mention one matter for inclusion in the list, Lordship? It was filed in November 2025, Lordship. It's still now it's not been heard once, Lordship. It's running in item number 750 of monthly list. Senior cities, Lordship, let it be included daily list, Lordship. Lordship, look, actually, sir, senior citizens has been outside from his house, Lordship.
Yes, sir. My lord, may I be permitted to mention, my lord, for inclusion, my lord. Yes, my lord. Mind is for you.
Matter for upgradation. Item number 750 of your monthly. But the petitioner is being forcibly restrained to enter her own home by her brother. To enter her own house by her brother.
Sorry, I will complete.
The matter is regarding I am the owner of a three-story building. The topmost floor, he runs a charitable kindergarten. The article is that the petitioner owns is under padlock by the.
Lordship, may I be permitted?
The bank
Mention for inclusion in the list. Lordship, for inclusion in the list. It is being filed in November 25. It is not yet heard and yes. It has not been heard yet. Then, it has not appeared in the list. We have filed it in. This Lordship has not appeared.
Lordship, may be permitted to mention for inclusion, Lordship.
13 March, the writ petitioner died and the substitution petition filed on 13th April. It was not heard yet. Deeply obliged.
May I permit to mention new motion, Lordship, for inclusion. New motion for inclusion, Lordship. Month of January, Lordship, this year. It not appearing in the list, till Lordship. Lordship, it is
Can
not.
permit to mention the matter, Your Lordship. This is a very urgent motion. It's about the former MLA. It's continuously 3 arrests has been made, shown arrest has been done, and 3 FIRs has been made. In 3 cases, the trial court has granted bail, and on that day only, they are giving shown arrest to the petitioner. Now it's 4th FIR, Your Lordship, in one single month, and now we have information that it's about 11 FIRs which will be filed. Now, whenever a petitioner gets bail from the trial court, we have filed it. It's item number 77. 3 to 4 days earlier, Your Lordship. It's a very urgent motion. Your Lordship, kindly fix a date, Your Lordship.
My Lord, I'm liberty to mention for inclusion in the list, matter filed on January. Not yet been listed, no order yet been passed. My Lord, why I'm mentioning today there is a civil court order where police is directed to maintain the status quo. My Lord, police is not working, my Lord.
Mention for inclusion, my Lord. Mention for inclusion. Inclusion. 25 matter. At 2025. 2025. Not yet hard.
My Lord, may I be permitted to mention for upgradation, my Lord. My Lord, father has been driven out by his son, my Lord, from his own house. My Lord, the father has been driven out by his own son from his own house, my Lord. That's my
Well, for non-prosecution. Yes, madam. Item number 97. Not today's list, my lord. I have to check today's list.
Your Lordship, if I may be permitted to mention a matter for inclusion, it lies in the monthly list as 749. Does not come up for hearing even once. It was filed in 2025.
Lordship, may I?
For inclusion in the list, my lord. Contempt application. My lord, contempt application of this year. My lord.
My lord, I am the petitioner in person. May I be permitted to mention a matter?
2023 matter. Yes. My lord.
Lordship, may I permit?
My lord, this matter was appeared. The
hearing matter, wait for some.
My lord, no hearing matter. Motion.
Very well. Wait. 2023 matter mentioned after publication of the combined list. I will not permit the matter to be included. Sorry. Yes.
My lord, I am the petitioner in person. May I be permitted to mention matter?
When dismissed for default? 8th of this month. Monthly list of August. Under the heading application.
Lordship, may I permit to mention a new motion inclusion in the list? Matter of 2025, Lordship.
Matter of 2025.
Filed on November 2025.
It is appearing in the list.
My lord, December month list 2025.
What was the order passed?
Not yet heard, my lord.
No order passed.
Not reached item, not item.
So why matter went out of list?
My lord, lack of change of determination. The matter was last on the lying in the bench.
Sir, this is for inclusion in the list. Regarding yes, this is for inclusion in the list.
Of which year?
26th year.
20. What was the last order passed?
For
when you filed it?
For motion.
No, you have to indicate the details. Sorry, with the details mentioned on next Monday. Yes.
Sir, I am praying for inclusion of the list. There are 3 case number, can number 1, 2002.
Can for what?
Can for 1.
Can for what? What you are praying for in the application?
Restoration.
Mention on next Monday. Yes. You are not ready.
This, my lord, on the last stop. I'm sorry, my lord. By your lordship's grace, my lord, the public parade of my husband has stopped. But we both are in custody. My lord, last day I missed the list. My lord's pleasure was to fix it on 4th, my lord. 4th of August. Only, my lord, in case it is not taken up, it's very urgent, my lord. I'll mention before your lordship. In case it is not taken up.
My lord, may I be permitted to mention a matter for inclusion? It was the
It was filed in the month of December 2025, my lord. And it is not running in the monthly list of.
Never heard.
No, my lord, not heard.
Last order 2025, nobody believe it, that it was never heard. Show me the status of this matter. You will get it from the system. Yes.
My lord, I am the petition
for inclusion in the list. It is filed on 25 December.
Mention after publication of the combined monthly list of August. 25 matter. Yes. Yes, please call the list.
My lord, I am the petitioner in person. May I
Yes.
I have two matters, WPA 3169 of 2026 and WPA 13817 of 2024.
Item numbers.
Sir, both the matters are been the assigned matter.
Item numbers.
Actually, it's in the running in the monthly list 1500 something.
No, it is not possible to find out the writ petition number. You have to indicate the item number.
In that case, may I, Lord, my matter can be released.
No, you have to indicate the item number. Sorry.
Sir, I had earlier mentioned, but I have
Please call
already
the list.
mentioned.
May I be permitted
Nothing was taken.
No further mentioning. Sorry. Item number
My
1.
Lord, it was earlier been mentioned. It was not taken care of. Can it be released?
Reason, my lord, violation of Indian Constitution. The petitioners, my lord, are major, educated. They have decided to marry one another of different religion. Now some third agency comes in and goes on threatening, forces the family to sign certain documents.
Why cap of North Bengal?
Oh, Bengal, part of Bengal.
I thought your state coming from Darjeeling.
No.
Yes.
Far
yes,
from
yes, Mr. Bhattacharya.
Now, my lord, kindly sees, my lord, how the interference goes on in personal life and personal affairs. It's very unfortunate. These are the
just
notice under Special Marriage Act for solemnization of marriage. Page 26.
Yes, what is the matter of?
You cannot marry on your own independent choice of a person of different religion. That's the intervention by the third quarter.
This problem is facing by the groom or bride?
My lord, both are different. Both are different, lordship. What's going on?
Now, what police authority will do?
Well, we have immediate complaint to the police. Well, this is the life threat.
They are going to solemnize their marriage by registration.
Yes, under the Special
When the
Marriage
date
Act.
is fixed.
29th. Proposed registration date is 29th of July 2026.
But I'm telling you, give some protection.
No, I'm telling you, Lordship, no protection is as such required because adequate steps has been taken by the police. I'm telling
Citizens, senior
29
citizens of adult citizens of the country cannot marry according
Yes,
to
of
their
course. Of
will
course. But we have
and
to stand on
decision.
that way. But we have initiated proceedings 129 of the BNSS, but which says regarding peace and tranquility. Already the proceeding has been drawn up. This is number one. And so far as police protection is concerned, your Lordships knows in terms of the PRB, they need to file an application under section 669. So that
court can direct.
Yes,
Court can direct.
Your Lordship can always.
Mr. Mujumdar, read court can direct.
No doubt about it. But I am not.
It's in
questioning-
violation of
But I am-
constitutional right
Yes,
under I am Article not- 21.
I am not questioning.
People, citizens of this country have right to marry according to their own
Rather,
choice.
my lord, police stepped in. My lord, police.
Can you show me any legal bar? If
No. There is no legal
if
bar.
bride is Hindu and groom is
My lord, kindly
Muslim.
see my report, para 4 and 5 once. Kindly see the role of the police. Adequate steps has been taken.
Paragraph 4.
4 and 5. And this has not been done by the outsiders. My lord, inter-family. My lord,
No. Mr. Badrina,
Why inter-family there will be fear?
They are fighting. We have stopped it.
No, there will be resistance. Why inter-family there will be resistance?
Yes, that is the reason we have stopped it. So that they cannot do so. My lord, kindly see the report.
Kindly see below the concluding paragraph. রিপোর্টটাই
এটাকে পোস্ট করে এটা কি ভুলটা কি লিখেছে
ও নিজেই তো অর্ডার চেয়েছে ও নিজেই তো বলছেন এসে অর্ডার
না stand of the police you are blaming police
No,
so
I
this
did
is
not
the
blame
stand.
police. আমি যে পুলিশ অফিসার হলে ওগুলোকে ধরে নিয়ে এসে থানায় আটকে দিতাম
ফ্যামিলি মেম্বারদের আটকে রাখা
ফ্যামিলি মেম্বার না দেখো তুমি
আমি এটা কি
না 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 তুমি পিটিশনটা পড়োনি বজরং বলি and others they are extreme constant threat. এটা আমি নেবো মার্ক করবো
Yes, already police has decided give a copy to. I have already given. Last paragraph, last but one paragraph, penultimate paragraph.
Look, this is more serious. May I read out? Later on 26th of July 20.
No, after that.
This is to be mentioned that the petitioners, two adults and exercise of free will, they had chosen to marry and interfaith marriage between them, so and so. Police authority has no scope to intervene into the matter directly without any order of direction from the Honorable Court. However, adequate police.
No, before that, this is to be mentioned that.
Yes, he says the position of law. Then
No,
he says,
it says that that however adequate police protection has been ensured to prevent any undue incident which may hamper the public peace and tranquility.
Yes.
And the life and liberty of the people as well as the family members of the petitioner. And it is stated that two adults in exercise of their free will, they had chosen to marry.
That is the position that they cannot deny. But when they say the peace and tranquility of the locality, the others will come and create hullabaloo.
On 29 July, the marriage is scheduled.
Yes.
By way of registration.
Yes, that's
now
notice.
They have to go to the registration office and marriage will be solemnized.
No, the registrar will come to their place of determined by them. 29 July is a date fixed. Kindly come to page plot.
My lord knows the topography of that area. It's Ulop area.
The only thing
the mixed population, I'm telling you, lordship, the topography. So adequate steps has been taken by the police to prevent any kind of peace and tranquility. And that is the reason. No, you have to also give protection to the to bride and groom, so that they can solemnize their marriage. Maybe interfaith marriage, but there is no. We are not saying so. But there is no legal bar, Mr. Mojumdar. There is how you, being the Advocate General, you can oppose this. No, I am not opposing. Additional Advocate. Mulad, I am saying, Mulad, I am not opposing it at all.
Mr. Mojumdar will not.
Mulad,
But kindly
see my report.
Kindly see page 29. Who are creating trouble? Kindly see 29, and they will come and create chaos, and they say maintain peace, don't marry.
And that is the reason 120 proceeding. That is the reason adequate police protection will be there, so that no breach of peace can take place. The scope of a 129 is very vast, my lord. It's a quasi-judicial proceeding.
These interfering below the bodies should be below taken proper care of, then everything will be peace.
Rather, my lord, if your lordship see page 5, my lord, we have asked them, you please lodge a complaint so that we can draw up the FIR. They refuse to do so. Kindly see para 5.
Complaint was lodged. You
No,
said
that is not any cognizable offense.
Ah.
Straight 506, my lord. It's a non-cognizable offense.
the violation of constitutional rights is cognizable.
How the FIR can be registered? My lord, kindly see if somebody is
No, it's not a question of registering FIR. Court
Yes.
is not considering this.
Lordship.
Two adult citizens of the country.
I am not standing on
of
the
our
way, my lord.
country have decided to marry.
Yes.
Maybe it is an interfaith marriage. But if there is resistance, then police has to be
That is
directed.
reason 129 has been invoked in the locality. It is not of the person concerned. 129 always of the locality.
না ঠিক আছে যশো অর্ডার দিচ্ছি রাজীবকে নেমন্তন্ন করে দাও রাজীবকে নেমন্তন্ন করতে বলো।
Matter is taken up for consideration in presence of the learned advocates representing the parties. Stop. Mr. Vikas Ranjan, next paragraph. Mr.
সবাই
Vikas
করেছেন,
Ranjan
intact
Bhattacharya,
family.
learned senior advocate representing the petitioner, submits that that the petitioners being adult citizens adult citizens have decided to marry by registering their marriage on 29th July 2026. But it is an interfaith marriage. There is furor in the There is furor in the locality. In the local, as a result whereof both the petitioners are
না হয়ে গেছে তুই এসছিস
are apprehending that they will be restrained from solemnizing marriage, resulting which prompts them to approach this court with the present writ petition. Stop. Petitioners pray for direction upon the concerned police authorities to provide adequate protection which would permit them to marry. Stop. Next paragraph, Mr. Rajdeep Mujumdar, learned senior advocate representing Mr. Rajdeep Mujumdar, learned additional advocate general, represents state respondents and has filed a communication dated 26 July 2026 of Inspector in charge, Ulubidia Police Station, Howrah, and same is taken on record. Stop. A copy of the communication dated 26 July 2026 is made over to the learned advocate representing the petition. Stop. Next paragraph, it is disclosed in the communication that certain steps have been taken by the concerned police authorities for maintaining peace and tranquility at the local, and non-cognizable report number 553/2026 dated /26 dated 24 July 2026 under section 126 BNSS has already been submitted to ensure peace and tranquility. Next paragraph. Petitioners have approached this court seeking protection which would permit them to marry, and this court does not find any hindrance, even if it is a case of interfaith marriage, since petitioners are adult citizens of this country and they have right to choose their life partner. Stop. Next paragraph. Therefore, steps taken by the concerned police authorities, as it is as are disclosed in the communication dated 26 July 2026, are not adequate, since since such communication reveals steps have been taken to maintain peace at the local, so that no untoward incident takes place. Stop. Considering the case made out on behalf of the petitioners, court finds it apt to direct the concerned police authorities to provide adequate protection to the petitioner on the day of their marriage, scheduled to be solemnized on 29 July 2026, so that they can complete the formalities of registration of marriage. Stop. Inspector in charge, Ulubidia Police Station, being respondent number
29 July তুমি জানিয়ে দেবে কোথায়
8 is directed to provide protection to the petitioners who are going to marry on 29 July 2026, so that no untoward incident takes place and petitioners ought not face any difficulty. Stop. Inspector in charge, Ulubere Police Station, is directed to file a report by 7 days thereafter. Stop. List the matter under the same heading for further consideration on 10th August 2026. Affidavit service filed on behalf of the petitioner is taken on record.
No.
We will prevent them from marrying.
No, we are not preventing, my lord. We are
Yes,
not
Mr.
preventing.
Dr.
My first statement was we are not against the marriage.
Matter is
Stand
over.
of the police authority.
Matter is over. Matter is over. Yes.
Item number 2. But item numbers 2 and 3 may be taken up together.
না একটু পরে বলছি আমি একটা ম্যাটারে ঢুকেছি
Item 3, my lord, I have a leader.
Yes.
If your lordship may kindly take up item number 3 first.
Yes.
I'm grateful, my lord. My lord, in item 3, this is a petition because which has been filed being aggrieved by the illegal and arbitrary exercise of authority by R8 to respondent 8 to 10.
Miss John, you are representing both the petitioners in both
No,
the matters.
I'm representing the petitioner in item number 3. My friend is representing the petitioner in item number 2.
Yes. So, Mr. Dotto, you both of you want to place item number 3 first.
Yes.
Yes, Miss John.
Can I continue, my lord?
Yes, you can continue.
Please, my lord. My lord, this is against the arbitrary and excessive exercise of authority by respondents 8 to 10, who are officials attached to the STF. Now, my lord, if your lordship was to come to page 6 of the petition, I'll just put the factual matrix on record. Page 6, paragraph E. Your lordship has it?
Yes.
Yes. On 20th of June 2026 at about 11:30 p.m., while the petitioner was returning to his residence on his scooty after completing his work at the office situated at 121 Kalighat Road, Calcutta, he was suddenly intercepted near so-and-so by a group of approximately 4 individuals who were wearing plain clothes and who did not initially disclose their identity.
So your grievance, Miss John, your grievance is that without issuing any notice under section 179 vis-a-vis 94, these steps are being taken in connection with the pending criminal prosecution.
In which I am not accused.
But at the same time, it has to be taken into consideration that for the sake of taking forward the investigation towards logical conclusion, certain steps are required to be taken.
That's right. I completely agree with that. Can I just respond to that?
Yes.
It cannot be my case that the police does not have the power to investigate, inquire from any person who's familiar with the facts and circumstances of the case. But it is my case that they have to do so as per law. That's all I'm saying. Now, picking up someone at 11:30 in the night, taking him to a safe house, keeping him there till mid-morning, shifting him to another safe house, being interrogated by different people. He is not allowed to contact his family members. He is not allowed to contact a lawyer. Between the 20th of June and 21st of June, I am taken to 3 different locations and I am finally released late in the evening of the 21st of June. Thereafter, on the 7th of June, would your lordship just come to Annexure P2? Now, they give me a notice under 179, page 51.
Just a minute, Annexure P2, page 51.
51.
So this notice is post 21st June.
That's right. This notice is ostensibly of 28th June, served on me on WhatsApp. That's my next page number. On the date when I'm required to go on 7th of June itself at 2:43 p.m.
So your contention is that the alleged incident of taking the petitioner to an unknown premises or location on 20 June 2026 was not backed by any notice. Or
not backed by any notice. And my lord, your lordship we are all officers of the court. You don't pick up someone at 11:30 at night, keep him through the night, without him being involved in some grievous offense. I am not involved in this FIR 133 of 2026, which they are investigating.
You are not the accused person.
I am not the accused person. They
Yes,
want
yes,
to find
that-
out
yes.
the whereabouts of an accused person, for
Yes,
which
what
I should
you
not
are-
be
How
subjected to.
is
My lord,
without any notice under
it is not a correct
179.94.
statement. No, it is not a correct statement. We have only called him as per the notice, and pursuant to that notice, he appeared, but he was questioned and subsequently.
Show me any notice.
Yes,
which was issued prior to 21st of June.
This is
20
only
June.
notice. Before that, no notice was given to him.
So how he was taken?
His
taken to
submission.
a
No,
taken
it is
to
a wrong
unknown
submission.
location.
Nothing, no, my lord, nothing has been done. Kindly see the case. Why it is so, my lord, the magnitude of the case. Government land was sold.
I know.
Yes.
Who is the accused person? It is there. 133 that criminal prosecution you have it is indicated in the writ petition. But
133
in yes, 133 2026 dated 5th June 2026.
How it stand, my lord?
Now the thing is this: you are investigating very well. You can. You have a privilege to investigate in terms of relevant provisions. But can you take a person without any, or can you call a person, or without any notice? Can you?
No such incident ever occurred.
Can you take such steps as it is alleged on?
They are alleging this. They are alleging this. Milord, we have followed the law. We can, Milord, kindly see this, Milord. Our report. How, Milord, the notice?
Unnecessarily petitioner will come before this court with a writ petition.
Yes, that is very important.
Now, Milord, I am telling you, Lord.
What saying?
Milord, kindly see, Milord, kindly hear me for a moment. The wife of the principal accused.
And the fault of the petitioner is the petitioner must have petitioner accompanied family member of that accused person to court.
No,
obtaining bail.
Milord, no. This is not the case, Milord. I am telling your lordship. Milord, there was continuous telephonic conversation so far as the principal accused concerned and this person.
Yes, court is not going to pass any order which will fetter your right to investigate. But that does not mean that you will do anything which is divorce the law.
Well, only to frustrate the investigational proceeding, this writ was filed. No, Lord, no such incident ever occurred. Lord, kindly show them one document that he was picked up. So kindly ask them.
How can there be a document of picking up?
Or any CCTV
Can there be a document to pick up?
Anything.
No, is it your case that nothing happened?
Nothing happened on that
nothing happened on.
Let them file it on affidavit. If I am wrong, I will apologize to this
Let
court.
them file affidavit.
Let them file it on affidavit that nothing happened on between the 20th and 21st.
You are absolutely correct. File it, put it on affidavit.
Lordship.
But and in my case, but there is a
I will hear
I'm
you.
sorry.
Mr. Datta. Issue. Matter is taken up for consideration when Miss Rebecca M. John, learned senior advocate representing petitioner, appears on virtual mode and submits that petitioner was taken to an unknown location on 20 June 2026 at midnight within bracket 11:30 p.m. and petitioner was released on 21st June 2026 at night in night. Stop. It is also submitted that petitioner was interrogated in connection with Shalboni PS case number 133 / 2026 dated 15 June 2026. But steps taken by the concerned investigating agency on 20th June 2026 / 21st June 2026 are without any notice either under section 179 79 BNSS or section 94 BNSS. Stop. It is stop. In the same breath, it is submitted on behalf of the petitioner that police authority, investigating authority has can investigate aforesaid criminal prosecution, but in course of investigation, if cooperation of the petitioner is required, petitioner is ready to cooperate, but steps are required to be taken by the concerned investigating agency in accordance with law. Stop. Without issuing valid notice prior to 20th June 2026, such steps taken by the concerned police authorities amounts to extra legal coercive action which is impermissible under the law. Stop. Next paragraph, Mr. Mujumdar, learned additional advocate general, appears on behalf of the state respondents and disputes submissions made on behalf of the petitioner. Stop. It is submitted that whatever steps were taken for investigating Shalboni PS case number 133/2026 dated 5th June 2026 were in accordance with law and due notice were issued prior to steps taken for interrogating the petitioner. Stop. It is also emphatically submitted on behalf of the state respondents that no incident as alleged took place on 20
petition.
No incident as alleged in the writ petition took place on 20 June 2026/21st June 2026. Stop. Next paragraph. Who will affirm affidavit?
What are the investigating
Officer.
Yes.
Next paragraph. Having considered the submission made on behalf of the petitioner, whereby facts alleged in the writ petition are disputed, investigating officer in Shalboni PS case number 133/2026 dated
STF. These are STF.
STF.
They are not the investigating body.
Milord, there are additional investigating officer. There are provision in the Milord PRB for the additional investigating officer.
Milord,
Shalboni, it is not a Shalboni PS
It is Shalboni PS, but now the investigate and monitoring part is taken care of by this STF.
By the STF.
So then the investigating officer, Shalboni PS case?
STF.
Oh, Shalboni STF?
No, only STF, Special Task Force.
Milord, Shalboni PS case has an investigating officer. These STF officers are monitoring the investigation as high.
And steps taken by the STF.
Yes.
Then the investigating officer who is part of police authority or STF to affirm affidavit?
The STF.
STF should.
So whether the concerned authority of STF is made party?
8, 9 and 10.
Yes, my lord. We have made specific allegations.
8, 9 and 10.
8, 9 and 10.
আচ্ছা কি বলছিলাম দেখো Sub-Inspector of Police, Special Task Force, West Bengal, being respondent number 10, shall file an affidavit by 10 days from date.
In opposition, affidavit in opposition.
No, not opposition. Only affidavit. By 10 days from date, disclosing steps taken in connection with Shalboni PS case number 133/2026 dated 5th June 2026. Whereby petitioner herein was interrogated. Stop. List the matter under the same heading for further consideration on. August 2026.
As your lordship.
My lord, can I just make one additional submission, if it so pleases your lordship? My lord, in my prayers, because I am a citizen, I don't have the wherewithal of the police agencies. The only way I can prove what I've said is because I made a statement on oath. Can the police be directed, the STF be directed to preserve the CCTV footage of the area, as well as the cell phone locations of the police officers I've named? I'm not saying share it with me, but this honorable court should have the capacity to verify what I'm saying. If I'm wrong, as I said, I'll face whatever punishment is required under law.
But what CCTV footage he's asking for?
See, every police station has CCTV footage. Please, this is the law of the Supreme Court.
21st of June. You are asking for preservation of CCTV footage.
I'm asking for preservation of CCTV footage
20 June and 21st of June.
That's right, my lord. That's right. Of the locations that I have mentioned in my writ petition.
Our case is no such incidents ever happened.
Doesn't matter. So there will be nothing then. There will be nothing then.
If CCTV concerned respondent authority shall also make an endeavor to preserve CCTV footage of alleged incident dated 20th June 2026 / 21st June 2026. And to that extent, statement shall also be made in the affidavit to be affirmed in terms of the order passed today.
I'm grateful. I'm grateful.
Millard, your lordship may also call for, with the leave of my senior Millard,
yes,
also call for a report for the perusal of the court, not for us, of the tower location of geo tower locations of respondent numbers 8, 9, 10, and me.
They are now
For court's perusal. That is very important. I don't want to delve into all those things, because if it's a very serious issue. If I have made a wrong statement before the court on oath, I should be dealt with seriously. And if my learned friend's
Next
client has
paragraph,
given
a
him,
separate report shall be filed by the respondent number 10 shall be filed by respondent number 10 for perusal of this court, disclosing geo tower location
of 8, 9, 10.
of a respondent numbers 8, 9, and 10,
of respondent numbers 8, 9, 10.
police officers.
Yes.
and yes, of course,
Yes.
and the petitioner.
And the petition.
On 20th
That is
June.
not for on affidavit. You just place a report for perusal by this court.
I'm so grateful, my lord. I'm so grateful.
Which they use is
ঠিক আছে
রিপোর্টের সঙ্গে রেখে দাও আচ্ছা রিপোর্টের কথা বলা হয়নি a communication no it's a report dated 21st July 2026 of Superintendent of Police Special Task Force West Bengal is filed today and same is taken on record.
the affidavit of service.
Affidavit of service টা বোর্ডে করে দাও
I'm grateful.
now it is being investigated upon by STF.
They are monitoring. They are
There
monitoring.
is provision in the PRB for associate investigating officer. Suppose a case can
The
be
police is investigating.
Yes.
In addition thereto, they
Yes.
are monitoring.
They are monitoring the matter to apprehend the principal accused persons. This is in terms of the PRB. They are the provision in the PRB. They can do so.
But in item number 2, Millard, your lordship may pass the same order. The only difference is, Millard,
2 is a completely different matter. I'm telling you, lordship.
very good. Then I'll place it.
Yes.
Very good. But what happens is, Millard,
Yes.
Millard, I am an architect. Now, Millard, I am known to Millard, the sister of so-called accused in a particular case, that is Shalboni PS case 133. But
At
on
133.
133. Now, Millard, I had assisted the sister of the so-called prime accused in coming to court, filing anticipatory bail application before the court. Therefore, Millard, the focus is on me. The purpose is to make I am not a witness, not a suspect, not an accused, nor a complainant. I am a complete, Millard, stranger to this, Millard, investigative process. Now, what they do is, Millard, on a particular day, Millard, from Moore Avenue, in a Baleno car, Millard, me, my senior officer, there was a driver and a
Your senior officer means?
senior officer in my office. And Millard, one gentleman called Raju, Millard, we come out, Millard, from Moore Avenue office and we were proceeding towards Baliganj. Millard, at one place, Millard, a Scorpio overtakes us. And Millard, we were compelled to disembark from that Baleno car, and me and the Raju, Millard, we were told to get up on the Scorpio. We had to. Police officers do this.
Your car was intercepted.
Car was intercepted. Thereafter, Millard, the driver of Baleno was told to sit on the left-hand side, and Millard, the Baleno was being driven by Millard, one STF personnel. Now, in this way, Millard, we were taken, Millard, from the, in that Scorpio to somewhere near Shasto Bhavan at Salt Lake. And Millard, the Baleno followed us. In the Baleno was my superior and the driver, our driver. Then, my lord, we were, my lord, interrogated time and again, my lord, at a place unknown to us. There's some Choto Babu who first came. He interrogated. There was some Boro Babu who came.
That was not in the police station.
That was not in the police station. And my lord, time and again, my lord, we were, my lord, interrogated, my lord, everything is described from paragraphs.
Not only intercepted your car, but
Yes.
you were taken to a location.
Yes, unknown location.
It is like a movie plot.
Yes, yes, absolutely. And when I
Subsequently released also.
yes, yes,
And
of course.
subsequently released.
Yes, yes.
This is their case.
In Bengali, Juto Mera Gorudan.
Ah.
Therefore, my lord, there's no offense. So therefore, now, my lord, in the meantime, what is done? There is
No notice, nothing.
Nothing. Then, my lastly, my lord, there's a respondent Sadiqul Islam. Now, when I get up in the Baleno, I'm sorry, in the Scorpio, my phone was taken out. Then, but I was told to disclose my password. Taking my password, Miller, the entire phone was navigated. All my personal whatever exchanges were there was looked into. Thereafter, Miller, it was put in a flight mode. Why flight mode? So that, Miller, our journey cannot be, Miller, recorded or, Miller, found out. Miller,
Cannot be tracked.
Then, Miller,
your mobile was put on flight mode.
Put on flight mode. And to cut the long story short, now the only purpose was to ascertain where, I mean the whereabouts of the prime accused, and my lord, to know and to harmonize me that why are you mixing up with a lady who is close to this thing, the accused. Now this, my lord, in my very respectful submission, is, my lord, completely uncalled for,
And
extra legal,
and Dior's law.
and the law. Now, my lord, the police has enormous power. If they feel that I am a witness, there is one mode of treating me. If they feel I am an accused, there is another mode of tracking me.
Mr. Mujumdar, whether this interrogation so far the case is made out in this petition can be done without any notice.
But I'm telling you, what is the background of the case? Give me 2 minutes. I'm telling you, Lordship. There is no such incident as ever happened. Rather, my lord, we have asked them to please accompany us because you are in continuous touch with the principal accused persons, but who is absconding and warrant of arrest is pending against him. They themselves has come to their car, to our office. They were interrogated for 2-3 hours. To their office. Well, we can
it was a 5-star hotel.
We can place that. They have
His
themselves.
office is a 5-star hotel. Therefore, my lord, we went for.
Anybody will be frightened.
My lord.
Anybody will be frightened.
No. My lord, they were after interrogation. They were released, and the next notice was given to them on 160, and they said immediately the writ application was filed. Your lordship knows.
How you can justify subsequent issuance of 179 notice?
My lord, he is. My lord, now he is in a category of suspect. He is not a witness, neither as an accused.
So whether he can be taken to a location or all on a sudden,
that is their case.
All of a sudden without any notice.
Well, that is their case, my lord. Your lordship is relying on their case. How, my lord?
Well, let them file an affidavit in here also.
ये के ओके छालले केन है की order होबे ये आस्ते बोलो.
They themselves came to the office with their car along with their driver. We have requested them. You see, there are a telephone conversation with you along with the principal accused for 2 hours. And why you are harboring them?
So
we know you are not an accused.
So therefore, police authority wants to interrogate him.
No.
Police authority IO wants to interrogate him.
Yes.
In connection with this 133 case.
Lordship.
Now, if that is so, so you could have sent a notice to him and ask him to appear.
But we have sent him immediately filed the writ application.
No, but is that as you are submitting, Mr. Mujumdar, that is after 25th of June incident. This incident took place on 25th June. So after 25th June incident, show me that any prior notice was given, either under 94 or 179.
No, my lord, cannot be. For suspect, no notice. What provision I shall give notice? My lord, kindly consider that. My lord, 179 says about the witness. He is not a witness because he is in touch with the principal accused person. Kindly see it once. 179. 179, my lord, the BNSS once. My lord, kindly see.
Very well, there is no provision, but where is the provision to pick up?
Where you yourself, my lord, they have gone to the office.
Yes.
Kindly see it, my lord.
Well, the case is that me of my own went to the STF office.
Yes, that is the case.
To implicate myself.
That is the case.
Harboring offender section 200 go like this. No, but it says any person can be send notice. Subsection 1.
179 heading is a bit confusing, but the section doesn't confine it to a.
It says police officers power to require attendance of witnesses.
No, read.
Now, my lord.
Yes. Any
Police officer making under may be order and require attendance before you any person be acquainted with limits of the own letter so and so information or otherwise appears to be acquainted with the facts and circumstances of the case. Lord, we are
but
not
it
of the
says
case.
any police officer making an investigation under this chapter may by order in writing require attendance before himself of any person.
Any person with the case, kindly, he is not.
So your contention is that this any person, this connotation has to be read with the heading of this.
Any person,
the heading of this section.
Any person acquainted with the facts and circumstances of the case. This is not he is coming because he is not the accused in the principal case. He is just harboring the offender, which is 112 of the IPC. Kindly say it once. 212.
Any person.
Let them show that there is a harboring case against him.
No, that will put.
But acquaintance with the facts and
circumstances of the case.
This expression has wider connotation.
No, my lord, it is relating to the case only. If he is the facts and circumstances of illegal selling of government land is concerned, definitely we can give him a notice under 179. But when he is harboring an offender, there are the conversation between the principal accused and this person. So under what circumstances he is not an accused, he is not a witness.
Then why subsequently notice was sent?
Subsequently, during investigation, we came to know, when we questioned him, we came to know that he is a witness. Kindly see our conduct also. It is not that their conduct should be seen always. Kindly see our conduct.
Definitely.
We could have arrested him there only. We did not do so.
So when on interrogation you found that he is a witness, then 179 notice. Yes, Mr. Dotto, how do you
No.
this?
Milord, to ascertain anything, any information from any person, there has to be a notice preceding that. It cannot be that somebody is taken from his house. Let us assume for argument's sake.
But under what provision this notice is to be served? Because 179 does not come, so that does not apply as.
But I'll bring those line of decisions, Milord. The 160 and 179, though, Milord, the heading says witness, but Milord, within the section, the body of the section doesn't confine it to witness. Please have a look at it.
Now, if Mr. Mojumdar's contention is this, once it is on interrogation, it is found that he is one of the witnesses, then 179 was invoked.
Very well. Now, how can that happen? It can happen by way of, say, going to my house, that we have come to you.
Today, police is investigating officer is considering the petitioner as one of the witnesses.
Yes.
Notices are being issued.
Yes.
That chapter is over. So what is the use of keeping this matter pending?
No, so far as
I will direct the concerned investigating agency to investigate and interrogate the petitioner in accordance with law by issuing prior notice.
But with respect,
that can be considered that is sufficient in order to protect your right also.
May I say this, in that case, what I have said in paragraph 6 to 35 will be either completely wrong, untrue, false, or it would amount to a stamp of approval in the way, Milord, I was dealt with on that day. Stamp of approval by the judiciary. Please consider this. If I have said something from paragraph 6 to 35 which is false, your lordship will take me to task in accordance with law. Otherwise, Milord, this will give an extra legal power.
So you want that the steps which were taken or the alleged incident which took place on 25th June, that the propriety of the investigating officer or investigating agency needs to be considered.
Yes, how can you
Kindly
pick
see
up
our
somebody
report.
Let
on
it
the
be
road?
decided on affidavit in that.
Kindly see our report.
Then put it on affidavit, Mr. Mukundar. There will be an affidavit. objection.
That's why I said, may pass the same order as
And
your
the court
lordship.
will direct that henceforth he will issue notice and
Yes,
Yes, yes.
problem. We have issued notice.
Because
As
I
soon as we
cannot-
have issued notice, they filed the writ application.
But I cannot have any grievance
with regard to
notices.
notices.
Ah.
But my lord, why this writ petition? Because of the apprehension. What has happened on 25th? And they have given, my lord, one Sadikul, my lord, your lordship will find is one of the respondents.
Well, if this
Respond
plea
number
is
eight.
being taken, that the matter will be throttled. Your lordship has seen number of cases where the person who are not an accused, who are not a witness, they are being called to give information. Your lordship knows that.
My lord, your lordships, my lord,
If entire power will be throttled by the court.
sir, may I say this?
So according to, there is a difference of witness and
Yes,
the person
yes.
who can
Accused.
be interrogated in connection with investigation.
There are two categories. One is accused, other one is witness. If somebody has information relating to the accused, the whereabout of the accused, police cannot call him. Definitely, police
cannot call. You cannot pick up.
Definitely, you can call him. Now, pick up, we have in our report, we have seen. On his own car, he and his driver went to the office.
Same.
Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Next paragraph. It is submitted on behalf of the petitioner by Mr. Kishore Datta, learned senior advocate, that petitioner was petitioner's car was all of a sudden intercepted by the concerned police authority on 25th June 2026. And he was taken to a place for interrogation in connection with Shalboni PS case number 133/2026. Did it so and so. Shalboni PS case number 133.
133.
Dated 5th of June
2026. Stop. It is contended on behalf of the petitioner that petitioner that concerned investigating authority ought not to have
6 or 37
taken the petitioner
37
to a place suddenly for interrogation without issuing prior notice. Stop. It is submitted that for interrogating petitioner who was not considered to be one of the witnesses in aforesaid criminal prosecution, investigating agencies is required to follow the procedure and issue notice. Stop. Steps taken by the investigating agency on alleged steps taken by the investigating agency on 25th June 2026 are questioned in this writ petition. What thereby seeking issuance of mandamus, declaring that such steps are honest in eye of law. Next paragraph, Mr. Rajdeep Majumdar, learned additional advocate general, disputes contention made on behalf of the petitioner by placing reliance on section 179 of BNSS 2023. Stop. It is submitted that on 25th June 2026, when petitioner's car was intercepted and thereafter petitioner was taken to a particular place for interrogation, he was not considered as one of the witnesses,
nor as an accused,
and he was not an accused. Therefore, issuance of notice as contemplated under section 179 was not called for.
Just one line, my lord, add, because he was in continuous touch with the principal accused person, and that is the reason to know the whereabouts of the principal accused person.
According to the concerned according to the concerned investigating agency, petitioner had acquaintance with the accused person, which led the police authorities to interrogate the petitioner on 25th June 2026. Next paragraph, from the respective submissions made on behalf of the parties, respective submissions made on behalf of the parties, it needs to be taken into consideration. Now, it needs to be done. Issue crops up whether in connection with the criminal prosecution and continued investigation thereof, a person alleged to have acquaintance with the accused person can be interrogated without any notice, without notice, or not. Stop. On perusal of section 179 of BNSS 2023, issue also needs to be delved into whether a person who is not treated or who is not found to be as one of the witnesses can be considered can be interrogated without issuance of notice and as contemplated on the plea that person has acquaintance with the incidents involved in the criminal prosecution. Stop. Next paragraph, let affidavit in issue, next paragraph, issue needs to be decided after exchange of affidavits. Stop. Let affidavit in opposition to this petition be filed by 4 weeks from date. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Stop. Next paragraph. Party shall be at liberty to mention before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits.
Well, these order preclude the investigating officer to issue further notices.
On that, my immediate,
however, this order shall not preclude the investigating agency to carry out investigation in accordance with law
after giving adequate notices
and interrogate the petitioner after following due process of law.
Yes. But my line I need to add, Millard, in the earlier matter also, because there also 179 was issued, and Millard, he did not turn up.
Yes.
But my immediate instruction is, Millard, no 179 notice has been issued to me up till now. Please record that, because my learned friend has submitted.
Mr. Dotto's submission record last sentence, it is also specifically submitted that till date, no notice under section 179 BNSS 2023 is issued to the petition.
And the last submission is, my lord, so far as my lord tower location is concerned, your lordship will find that there is a response number 8.
No, we are admitting. But we approaches Mudiali. He was
In
called.
previous case, there was a denial of this fact. Here, they are.
No, we are admitting. In our report also, we are saying
that
we asked
he
them,
has been.
please accompany us. We asked them, please accompany us with your car.
Yes, case there was a
But the last matter also, my lord, kindly the same line may be incorporated. Because there also 179 notice was issued. Lord, let him, my lord, go and comply with this notice.
That I have directed.
No, that has not been directed. my lord.
देखिए आगे मैं একটা देखो तो
One line maybe.
previous आगे मैं একটা হ্যাঁ ঠিক আছে লাইনটা শুনিয়ে এত কি পছন্দ হলো লাইনটা Yes, added. Mr. Dotto is there. Last this particular part of this order is also added in the previous order passed on that petition.
Subsequently, 179.
Deeply obliged. Call the next matter. Go outside and have conference.
সে তো রেকর্ড করলেন আইটেম নাম্বার 4
They have issued 179.
হ্যাঁ
They have not issued.
আমি তো পাইনি, সে তো হয়ে গেছে তাহলে।
Yes. But this 179 point is interesting. Witness.
Yes. Witness what is not in the section.
Until and unless you not decide that
The point is
of
interesting.
the investigating officer. The lordship knows there are two category of the person. One is an accused, other one is a witness.
Mr. Dotto, heading and the contents of
But there are from Privy Council it says
not in sync.
yes. But from Privy Council
That is my lord.
Wait.
That's a debate where which we take somewhere else. But why DNSS was framed, my lord, this dichotomy has not been.
We place Mr. Majumdar's judgment.
no. But this has but these was started.
179
In those
No, either he has to be a suspect of the case or he has to be a witness. From Privy Council 19. Yes, I know the matter. I have not one matter, at least five matters I have.
Acquaintance and suspect is not same.
Same. Yes.
No.
Different.
But acquaintance is something different. Americans do not call accused. Americans call suspect. And we try to distinguish between a suspect and an accused.
That was a straight
Accused is always a suspect. So long he is not
suspicion and credible information.
But there are two things. One is suspicion, other one is grave suspicion.
That is the difference.
Well, I shall demonstrate the entire scheme of the act, my lord, before your lordship on the next day. There is a gray area. It is true, my lord. My lord, now kindly visualize the situation. Person is not an accused, not a witness. Suppose he knows.
But one thing I must express that he is not a witness.
Yes.
A person is not a witness. And only on a suspect these steps can be taken.
But he is not even a suspect. I am telling your lordship. He is not a continuous touch with the principal accused persons.
Yeah, but it is a kidnapping case.
So no, it is not cannot be kidnapping. So Lord, we have asked us saying that you please give your phone, show me how many times you had a. Yes, it can be done. But I shall show you. I can show it to your. I can show it to you. Then power of the police. The power of the police will be curtailed.
Does it not breach privacy?
No.
Yes.
No, blood for the purpose of investigation,
They should follow the Telegraph Act and the rules.
no, when there
That they do not follow.
But I am telling you, lordship, when there is a concrete evidence that that person has a word with the principal accused for more than 2 hours,
Harboring an accused.
Bring the charge.
harboring an
that charge.
accused. So we need to verify that whether this person actually had a word with the accused, no, some other person has a word with the accused. Yes, deeply obliged.
My lord,
Yes.
my lord, service was done, but it was not effective, my lord.
Not complete.
No, my lord. So I'm praying
What
for
you are
not
praying
today.
for? You are for the state.
Private respondent number 4.
My lord, I'm praying for not today, my lord.
You are praying for registration of FIR as it appears. So what is the use of keeping this matter pending? Because court is not going to pass any order on a prayer seeking registration of FIR, since there is an alternative remedy available. So let me dispose of the writ petition permitting you to approach jurisdictional magistrate under section 175(3).
My lord, next date we will
Issue. That's why I have read your prayer. Virtually, it's a prayer for registration of FIR.
Okay.
Issue. Affidavit of service. On hearing the learned advocate representing the petitioner, learned advocates representing the petitioner and respondent number, you are representing. On hearing the learned advocates representing the petitioner and respondent number 4, it appears petitioner is aggrieved by inaction on the part of the concerned police authorities in registering FIR based on complaint lodged. Next part. There is an alternative remedy available under section 175(3) BNSS 2023 requiring the petitioner to approach jurisdictional magistrate in the event complaint is not transformed into FIR. Stop. In this regard, reliance is placed on the judgment of the Honorable Supreme Court reported in 2007-6 SCC 171, Aliu Padamsi and others versus Union of India and others. Next one. Hence, writ petition is not entertained and same stands dismissed. However, this order shall not preclude the petitioner to approach jurisdictional magistrate in pursuit of remedy. Parties to act on the servant.
Item number 5.
Madam, for the petition. This is the affidavit of.
And also,
Both of you are appearing for the petitioner.
petition that is on 20 is where it's your lordship.
No. It's the Sikh.
Yes.
What is the affidavit of service? The petitioner is the senior citizen and my lord the suffering from acquired disease and unable to work. My lord, earlier occasion my lord has heard this matter. Either the report is called for, either FIR has been started or not.
Yes, any FIR is registered.
Yes, ma'am. Preliminary report. That is second page, ma'am.
So already FIR has been registered. If you have any grievance with regard to the steps taken by the concerned police authorities, approach the jurisdictional magistrate. Whether somebody is to be arrested or not, or any other steps are to be taken, approach the jurisdictional magistrate. High Court will not permit it. Yes.
Face investigation can be face and fair investigation.
Yes, that High Court will not direct. Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Petitioner is aggrieved. But it appears that after filing of your writ petition, FIR was registered on 12 July.
Filing this application. There is my lord, writ petition can be in.
Aggrieved by inaction on the part of the concerned police authorities in taking steps based on complaint lodged. Stop. Prayer is made in the writ petition seeking certain directions upon the concerned police authorities. for taking forward the investigation to its logical conclusion. Stop. Next paragraph. Client advocate representing state respondents has filed a communication dated 20 July 2026 of inspector in charge Chinchura police station, and same is taken on record. Copy of the said communication dated 20 July 2026 is served upon the is made over to the learned advocate representing the petition. Next paragraph. It is disclosed in the communication dated 20 July 2026 that based on complaint lodged, a criminal prosecution being Chinchura Police Station case number 284/26 dated 12 July 2026 has been initiated and investigation is continuing. Next paragraph. If petitioner has grievance with regard to investigation being carried out by the police authorities, in that event, petitioner needs to approach jurisdictional magistrate under section 175(3) BNSS. Stop. In this regard, reliance is placed on the judgment of the Honorable Supreme Court reported in 2026 SCC Online SC 798 Sujal Bishwas Attavar and another versus State of Maharashtra. Next slide. Hence, writ petition is not entertained and same stands dismissed. However, this order shall not preclude the petitioner to approach jurisdictional magistrate in pursuit. Next.
Item number 6.
Item number 6, I'm for the petitioners, my lord.
Yes.
There is a, my lord, inadvertent error made in the, this matter is not pertaining to the present bench, my lord. This is falling
Not
under
pertaining to police.
present bench, no, my lord. That is the reason I'm not pressing the applications.
Not pressing this issue. At the time of call, learned advocate representing the petitioner submits on instruction that writ petition is not pressed. Stop. You are appearing for whom? Yes.
My lord, respondent number 9 and 10.
9 and 10.
I am led by Mr. Shiv Chakraborty, who is appearing for state.
You are for the state. Are you a paneled advocate?
No, I am not panel. I am led by Mr.
Don't appear.
Sorry, my lord, sorry, my lord. 12 and
Yes.
13. 12 and 13.
Respondent numbers 12 and 13. Mr. Das, you are appearing.
No, my lord. Mr. Chakraborty is in this matter. Mr. Shiv Chakraborty. My lord, I will assist your lord.
Shiv Chakraborty?
Yes, lordship. He is Mr. Chakraborty's junior.
Or Mr. Partho Chakraborty?
No, Mr. Shiv Chakraborty.
Respondent number কি বললাম 11 and 12. 11 and 13.
12 and 13.
Respondent number 12 and 13 and state respondents are represented by learned advocate.
Well, the police is not even a party in this matter.
Stop. Next paragraph. The writ petition is dismissed in view of submission made on behalf of the petitioner. Writ petition is dismissed as not pressed. Stop. Parties to act on the server property.
Grateful.
Those who are present, give their name only. Don't give names of others. Those who are present, give their name only.
I appear for the petitioner number 2 for the petitioner.
That I do not know. You settle amongst you. Application, application, if any pending, also stands dismissed. Who is appearing for which petitioner, you settle. And give the slip to my court officer, he will record names.
Item number 7.
7, I am for the private respondent. My lord, Mr. Orkopratim Chaudhary is appearing in this matter. My lord.
Yes.
Mr. Orkopratim Chaudhary is appearing in this matter. My lord, I was instructed to seek an adjournment on his behalf as he is medically unfit to appear before this court. My lord. My lord, may you please to fix this matter or keep this matter on any day at my lord convenience.
At the time of call, accommodation is prayed for on behalf of the petitioner. Stop. Hearing of this matter stands adjourned. State.
I am for the state. Private response. De facto complaint.
Respondent numbers?
Five.
Five.
I am for the state.
State respondents and respondent number 5 are represented by learned advocates. Hearing of this matter stands adjourned. List the matter under the same heading, under the heading motion in the monthly combined list of September 2026.
The same FIR, my lord, the same FIR, two accused.
Yes.
Out of which one has been appeared in the my lord list on 15 July, item number 12 has been dismissed by my lord.
Same. Oh, dismissed.
Another. Same FIR.
Same FIR, another accused. My lord, on the ground that my lord
anticipative bail is
pending, your lordship dismissed.
Oh, sir, and this order, this writ petition originated from
same FIR.
criminal prosecution.
Yes.
May I just suggest one thing? When placing the next, she asks for time.
Yes,
So
that
no,
is I did not object.
accommodate them, my not to pass the order, please. Not to pass the order. Keep it with you, my lord, file.
Yes.
We'll pass on the next day.
Next day. At the time of call, accommodation is prayed for on behalf of the petitioner. However, state respondents and respondent 5 are represented by learned advocates. Stop. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration.
Next week.
Next week, not possible.
Whatever.
August 2026. 18th August 2026.
No.
However, it is made clear that no further adjournment shall be granted on the next day. I'm keeping this order.
Yeah, I'll keep it in my lord file.
Lordship. Item number 8. Lordship, most humbly, my lord, I beg to appear on behalf of the petitioner, my lord. My lord, I have served, my lord. This is my affidavit of service, my lord. My lord, petitioner is, my lord, a Bargadar, my lord, and page 17, 18, 19, 20 are all the documents, my lord, which establishes his right as a Bargadar, my lord. I'm not before your lordship, my lord, for declaring my right as a Bargadar or to decide any civil dispute, my lord. I am before your lordship, my lord, only for the inaction as well as the overaction by the concerned police officers, my lord. It's my.
Who is for the private respondent?
I am for the private respondent.
What is your stand?
He is seeking for a declaration for a Borgada. My lord, that remedy lies in WPLRTT, my lord.
No, where is your right over the land in question?
I am the, my lord, kindly come to the record of rights. They have ended.
Now, are you laying any claim over the land in question?
No, I am on 1150.
Yes. So you have no claim over the land in question?
No.
In respect of which petitioner is claiming Borgada?
No.
Claiming as Borgada?
No.
Then why you have made him part of?
My lord, they are obstructing, my lord, and my dispute is not regarding obstructing, my lord. I have made the complaint to the police officials. Police officials, my lord, are directing me till the civil suit is pending. Do not go to the land and do not cultivate. And after that, my lord,
the civil suit is pending.
My lord, I have placed because, my lord, as their submission is that I have to declare the Bargadar right, my lord. I am not here, my lord, before your lordship for declaring as a Bargadar. I will consider my right before the civil court, my lord. But my prayer is very limited, my lord. When I have made the petition, my lord, after that also police is called, my lord. I have named the
today, if you have filed a civil suit,
lordship,
claiming a declaration that you are Bargadar in respect of the land in question,
lordship.
In that event, your right centers around Bargadar as defined under the Land Reforms Act,
lordship
55. Now, unless and until it is decided,
lordship,
if today during pendency court directs the police authorities to take steps which would protect your right as Bargadar, then what the civil court will decide?
Lordship, most humbly, no, my lord, to that, my lord, I have some submissions, my lord. My lord, I have also one judgment, my lord. My lord, I have also one judgment. My lord, kindly decide my lord, most humbly, my lord, kindly decide. My lord, kindly decide.
This court with
My
the
lord, I have one judgment. My lord, kindly record that, my lord. My lord, kindly record one judgment, my lord. My lord, most humbly, my lord. It is my most humble submission, my lord. My lord, most humbly, my lord, kindly record that my judgment, my lord. It is passed by this honorable court.
Has approached this court.
My
with the
lord,
present
passed by
petition
honorable, my lord, passed by this honorable court, my lord, Calcutta High Court, my lord. On
to take steps which would protect right of
my
the
lord, I
petitioner
have subsequent.
Bargadar in respect of an agricultural in respect of agricultural land in question. Stop. Stop. Next paragraph.
My lord, kindly, my lord, kindly consider my submission.
Not required. State
My-
respondents and
my lord, kindly,
respondent number
my lord,
4 and 5 are represented by learned
my lord,
advocates.
kindly consider, my lord, after that I have,
Submit learned advocate representing state respondents and respondent number 4 and 5 are represented by learned advocates.
my lord, kindly
Next
consider
paragraph.
the judgment and kindly
Hearing the
consider
learned
I have made.
advocates representing the parties, it appears that a suit is pending which was instituted by the petitioner for asserting his right as Bargadar.
Until then, my lord, I will not
the
be able
land
to
in question.
cultivate.
Stop. At this stage, if
My lord, police is threatening
no
me.
direction is called for, at this stage, no, at this stage, during pendency of suit, claiming right of the petitioner as Bargadar, no mandamus is warranted, thereby directing the concerned.
My lord, I have an order, my lord, judgment, my lord.
To take steps which would preserve right of the petitioner as
A writ is maintainable, my lord.
Next paragraph.
Most humbly, my lord.
Hence, present writ petition is not interfered with and same
My lord, kindly record my judgment and then
order
dismiss,
shall
my
not
lord.
preclude the petitioner to approach the appropriate forum.
Lord, I bow down to your lordship. Kindly record my judgment. My judgment record, my lord. My judgment is important, my lord. Kindly record that, my lord, so that I can taste, my lord. My lord, most humbly, my lord, my judgment is important, my lord. I bow down to your lordship. My judgment is very important. My lord, one judgment, my lord. Kindly consider that, and after dismiss, I will be bow down to your lordships, my lord. I have one judgment, my lord, passed by this honorable High Court, my lord. Justice Dipankar Datta has passed an order, my lord. And a writ is maintainable where the police is in excess of the statutory duty or in violation of the statutory duty. Kindly consider, my lord. Kindly consider that, my lord. And also, my lord, I have made complaint to the SP, my lord, that police is threatening me not to enter in the land, my lord. My lord, kindly consider the judgment, my lord.
Which part of the judgment?
Lordship, most humbly, my lord, I'm coming. My lord, kindly comes to my lord. My lord, kindly comes to my lord. I have not. Last but 3 page. Well, last but 3 page, my lord.
Just a minute.
Lordship. It's a. Kindly considers, my lord. And there is also one complaint, my lord. Kindly record this, my lord. Most.
Now come to the first paragraph
Lordship.
of this judgment.
Lordship.
Read it.
My lord, first page, first paragraph.
Yes.
Lordship.
Facts of the case.
Lordship.
Yes.
It is not in dispute that the respondent number 4 to 7 are the owners of the disputed land. It is further undisputed that the competent authority under the West Bengal Land Reforms Act has recorded the names of the petitioners Bargadar in respect of the same.
It is further undisputed that the competent authority under the West Bengal Land Reforms Act has recorded the name of the petitioners as Bargadar in respect of the
same case.
The grievance of the petitioners is that despite they being Bargadars, police authorities is not allowing.
My case is also same.
Here, your case regarding your right as Bargadar is pending before the civil court in connection with
No. In present case also it is pending. In present case also.
Court proceeded on the premise that you are the Bargadar.
No,
here you are the Bargadar. It is not a case. Otherwise, there was no necessity.
I am Bargadar. My lord, only because, my lord, I have to protect my dispossession, my lord, because they are dispossessing me, my lord, and I have made this
So then
subsequent
why
complaint.
suit is pending?
Huh?
Tell me why.
My lord,
suit is
only because, my lord, they're dispossessing. I have to establish my right because because they're new riot, my lord. My lord, they are saying that they do not have right, but they have come and say that I am the new right. I have bought the land, but buying the land, but does not disturb my statutory right being a
No,
bargadar.
but why, in that event, why you are claiming your right as Bargadar
My
by
lord, I'm not
instituting a
claiming
suit?
as a it is established, my lord. Kindly cease prima facie case, my lord. I've made out to the police. Subsequently, I've been threatened, my lord. Kindly cease my complaint.
You show me that you are the Bargadar of
I'm
the
showing,
land.
my lord. Kindly comes, my lord. Kindly comes to page 17, 18, 19, 20. My lord, kindly comes to page 17. It's a Mart Khasra, my lord, prepared in 1986. And it is prepared on the Mart, my lord. Record. Kindly comes, my lord. Kindly comes to page in 19 as well, my lord. My name is there, my lord. The riot's name, Jatindranath, recorded, my lord. They and my name is also there.
It is stated riot.
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 Riot is Jatindranath Dev. Kind no, no, my lord. My name is recorded. My name is recorded, my lord. My lord, my name is recorded. My lord, Bargadar name is recorded. Page 19.
Dismiss করছি তার আগে একটা প্যারাগ্রাফ অ্যাড করো। On behalf of the petitioner, an order of a coordinate bench dated 26 June 2008.
Page 20, my lord.
Relied upon. Passed on a writ petition being WPA 26883 of 2026. Stop. However, on perusal of the said order dated 26 June 2008, it appears that court proceeded on it appears that coordinate bench proceeded on the premise
Page 20. Only page 20, my lord. Only page 20.
competent authority under the West Bengal Land Reforms Act within bracket under the competent authority under the West Bengal Land Reforms Act has recorded names of the petitioners as Bargadar in respect of land in question, agricultural land in question. Stop. In the present case, it is not demonstrated before this court that the petitioner is Bargadar in respect of the land in question, and suit is pending claiming petitioner's right as Bargadar.
Page 20.
However, it is made clear that court is not considering in the present proceeding whether petitioner is Bargadar or not in respect of the land in question.
My lord, only right to livelihood, my lord.
In aforesaid consideration,
My lord, till then I will not be entered.
Order of the coordinate bench dated 26 June 2008 does not come in aid of the petition.
I will not enter, my lord. To then, my lord, I will not enter. I will not cultivate, my lord.
Yes, call the list.
Item number 9.
Your Lordship, I am for the petitioner. Led by Sipra Naskar. Your Lordship, service is not completed.
Yes.
Service is not completed, Your Lordship.
You are praying for a direction upon the police authorities for taking certain steps in connection with the investigation.
Yes, Lordship.
Now, for that, writ petition is not maintainable, but there is an alternative remedy under section 156(3).
The Lordship, respondent number 6 and 7 is living in the same premises of the petitioner.
Maybe, but you are seeking certain directions upon the concerned police authorities in connection with the investigation of Park Street Police Station case number 45 of 2026 dated 24th February 2026. For that, you have to approach jurisdiction magistrate under section 156(3)
Your Lordship,
or 175(3) BNSS. But writ petition is not, why writ petition will be entertained? There is an alternative remedy.
But Your Lordship, police personnel is not taking any action.
Yes, that's why if you are not satisfied with the action of the concerned police authorities in investigating Park Street Police Station case number 45 of 2026, dated 24th of February 2026, in that event approach jurisdictional magistrate. But writ petition is not maintainable as Supreme Court has said in the recent judgment of Sujal Vishwas Attawar. Issue.
But Your Lordship, the petitioner is lodging complaint.
On hearing the on perusing the perusing writ petition.
Your Lordship, the advocate on record is not present, Your Lordship.
Prayer
He is suffering from dengue.
It appears petitioner is dissatisfied with
Your Lordship,
steps taken
Your Lordship,
by the concerned police authorities in Park Street Police Station case number 45 of 2026.
Lordship.
Dated 24th February 2026. Stop. According to the petitioner, certain steps are required to be taken by the investigating agency for taking forward the investigation to its logical conclusion. Stop. Next paragraph. If petitioner is dissatisfied with steps taken by the investigating agency, or petitioner finds that finds inaction on the part of the concerned police authorities in investigating a case, in that event, approach has to be made to jurisdictional magistrate under section 175(3) BNSS 20. Stop. In this regard, reliance is placed on the judgment of the Honorable Supreme Court reported in 2026 SCC Online SC 798, Sujal Vishwas Attawar and another versus State of Maharashtra and others, comma, in paragraph 7, it has been succinctly decided that after registration of FIR, if party is not satisfied with the steps taken by the concerned police authorities, in that event, approach has to be made within the statutory framework. Stop. Hence, present writ petition is not entertained in view of availability of alternative remedy, and same stands dismissed. However, this order shall not preclude the petitioner to approach jurisdictional magistrate in pursuit of remedy. Parties to act on the server copy.
Item number 10.
At the time of call, no one appears for the petitioners and no accommodation is paid for. So, writ petition stands dismissed for default. Parties to act on the server copy.
Item number 11.
Yes.
In this matter, in the third round of litigation,
Service,
affidavit of service.
who is appearing for the
Your Lordship,
state?
I am appearing first. Your Lordship,
Use microphone.
Cause of action arose in 2025. Thereafter, actually, basically, this matter relates to illegal encroachment, and subsequently, they are now threatening us, life threats. In 2025, a FIR was lodged, a complaint was lodged. Police didn't took step. We approached the court. Then Honorable Justice Tirthankar Ghosh, who was then having the determination of police, or passed an order, reasoned order, page number 48. Kindly seize that.
Whether FIR has been registered?
Your Lordship, this is the report. An FIR has been registered, Your Lordship. Paragraph number 2, NCR 795 of 2026, 9th of July 2026. Registered.
No, no FIR was registered. It is non-cognizable. Report 795/2026 was submitted on 9 July 2026. Where is registration of FIR? Why you are saying yes?
No, Your Lordship, under 126, initiation has
Why
been
you
done.
have submitted that FIR has been registered without reading the instruction?
Your Lordship, on the last page, they have stated that this is civil in nature. In view of the aforesaid, it is allegation of police inactions are born out of official.
FIR is not registered at this stage. What
Lordship, kindly,
if you are seeking for?
kindly come to page number 48 of the petition. The order passed by Honorable Justice Ghosh, Tirthankar Ghosh. Previously,
yes, no breach of peace and tranquility.
Yes,
to maintain tranquility. Yes,
Lordship, then supposedly we preferred an appeal. And
so why again you have preferred another?
Every day, Lordship, we are getting death threats.
You have preferred appeal against this order?
Yes, we have subsequently preferred an appeal, and the division bench upheld that the order of Justice Ghosh is just and fine, and they didn't want to interfere with the order. But the thing is, Lordship, we have did a representation to the police recently, and we are getting death threats every day. Illegal encroachment. Huh? Hang on.
Why you are filing writ petition one after another?
Lordship, kindly.
Already on a same cause of action, another writ petition was filed, and this matter went right up to Honorable Division Bench.
Lordship, I understand, but
Yes,
we
sir.
are getting death threats.
Matter is taken up for consideration when it appears that matter is taken up for consideration in presence of the learned advocates representing the petitioner and state respondents. Petitioner prays for direction upon the concerned police authorities.
Chief, they are claiming to be the Borgadar, but we are
For
the actual
acting in
Borgadar.
accordance with law and to take steps based on the complaint lodged. Stop. According to the petitioner, inaction on the part of the concerned police authorities prompts him to approach this court with the present writ petition. Stop. State respondents are represented by learned advocate who submits that issue involved in this writ petition is civil in nature. Stop. Next paragraph. On perusal of the writ petition and hearing the learned advocates representing the parties, it appears previously a writ petition was filed being WPA 3160 of 2025 by the petitioner, which was disposed of by a coordinate bench. Video order dated 21st February 2025, thereby directing the concerned police authorities to ensure peace and tranquility at the local. So, it was also held therein. Trouble started due to acrimony between petitioner and private response. Stop. Next paragraph. As coordinate bench already passed order by disposing of writ petition being WPA 3160 of 2025, কি বললাম? হ্যাঁ, পড়ো। Which was not interfered with by the Honorable Division Bench while disposing of intra-court appeal being FMA 563 of 2025 on 10 December 2025. No further order need be passed on this writ petition. Stop. The writ petition stands dismissed. Urgent xerox.
But Lordship, some protection.
Nothing. On same cause of action, one after another petitions are being filed.
Item number 12. Item number 12, my lord, I am being led by Mr. Nag, my lord. No, my lord, I'll start the matter, my lord.
Yes, you start. Yes.
My lord, this is my affidavit of service. My lord, the petitioner's mother is a 66-year-old pensioner. My lord, the petitioner's mother used to maintain an account in the Indian bank. V-Day a notice dated 7 July 2025. The respondent number 7, my lord, a station house officer, cybercrime police station, Ghaziabad, sent the notice to the bank. My lord, the subject matter of the fraud is rupees 1350, which is maintained in my account. My lord,
relevant document.
My lord, the notice
from where it can be ascertained.
My lord, page number 35, my lord.
That layer of transaction and the amount involved.
My lord, page number 35, my lord. My lord, a total of 17 accounts had been seized, my lord. Out of that, only one account was maintained by me. But the amount seized is rupees 1350. Lord, the notice was sent to me by the bank, my lord. By the Indian Bank Bojwaj branch.
Have you served notice upon the investigating
My lord,
agency?
I have
It
served
is
notice to
complete.
all, my lord,
Service is
my lord,
complete.
service is complete, my lord. My lord, to respond number 7, my lord, to respond number 9, and also 8, my lord. And also the commissioner of UP police, my lord, respond number 6.
When they were served.
My lord, first, my lord, your lordship is
When they were served, respondent number 5, 6, 7.
let me check. It got delivered, my lord, on 16/7/2026.
State is represented.
But I was a state one.
Yeah, for the bank.
No, my lord, but I was
State.
always state one. Well, what?
Bank needs to be heard.
Bank also
And
has been
have
served.
But
Generally, bank appears, but today nobody is appearing.
Inspector in charge, Bojpoj police station send one report, my lord.
What report is
Nothing, my
stated?
lord.
You are not the investigating
No, my
agency.
lord, no.
Then
No, only
Only
difficulty
matter
is that 1350 is that
when bank was served,
bank
Indian Bank branch manager, Bajbaj branch.
because it has been served.
Your account is lying there at
yes.
Bajbaj branch.
Yes, it is on 13 July.
Serve another notice and come back. Issue. File your affidavit of service. Affidavit of service filed on behalf of the petitioner is taken on record. Learned advocate representing the petitioner submits. যেখানটা অসুবিধা হবে বলবে।
Statement আমাদের দিতে হবে।
Learned advocate representing the petitioner submits account of the petitioner is debit frozen in connection with investigation being carried out by concerned investigating agency relating to a cyber fraud case. Stop. It is also submitted in reference to a document at page 35 of the writ petition that alleged transaction linked to the account of the petitioner is at layer 2 level and alleged sum is rupees 1350. Rupees 1350. Stop. Next paragraph. However, bank authority is not represented today. Concerned bank authority is not represented today. Stop. Next paragraph. Client advocate for the petitioner is directed to serve another notice upon branch manager, Indian Bank, Bajbaj branch, being respondent number 9 by 7 days from date, enclosing copy of the order passed today, and file affidavit of service on the next date. Stop. Hearing of this matter stands adjourned. List the matter under the heading new motion on August 10th, 2026. Stop. Next, however, it is made clear, in spite of service of notice, if bank authority remains unrepresented on the next date, comma, writ petition shall be heard in absence of bank authority. Give your evidence. You are not an appropriate contesting respondent.
No complaint
because
with the
you are
lodge.
neither bank authority nor investigating agency.
And only cybercrime, Ghaziabad is the responsible.
And in these matters, I have seen in other cases that in spite of repeated bank appears, but in spite of repeated notices, investigating authorities are not represented.
The amount is meager, so they don't follow. Even in my account, 1000, there is a lien, but there can be lien on the amount.
It can happen with anybody.
Anybody.
Yes,
Pan wala, anybody
Yes.
saving your account.
Come back.
By them also. Bank of Oblige. State order.
Item number 13.
I am for the.
I am for the respondent.
My lord, I am for the private respondent.
Private respondent, my lord, served, and my lord filed affidavit of service. My lord, I have been residing in my paternal house. Two brothers are there who are living there. My lord, I am the younger brother. My lord, on 4th,
You are applying for the private respondent.
4th June, my lord, 2026. When, my lord, I came to know, my lord, that my padlock of the room, my lord, is broken by the private respondent. That's why I registered them. But severely beaten, and I was admitted in the hospital, and the report is there, injury report. I lost complaint to the police.
Where is your complaint?
My lord,
Complaint,
Wait,
my lord,
wait.
page 23 and 4, first complaint, which was not acknowledged, my lord, by giving me the GD number. Subsequent complaint, my lord, page, my lord, 29 and 30 to the officer in charge. I am now ousted from the house because they are threatening always, my lord, to kill me if I enter there. My protection is required, my
food.
My assets are there.
Food
We have, my lord,
food
food
zone
extract.
Page 23.
23 টা আগে একটা
হ্যাঁ এটা মেন কমপ্লেন্ট
এটা কবে
অন দ্য বেসিস অফ দিস কমপ্লেন্ট এফআইআর হ্যাজ বিন রেজিস্টার্ড
এটা কবে করব
এটা আপনার
পেজ 29
23 তে অবশ্য
23 তো আগেরটা
হ্যাঁ
অর্জুন
29 এর পরে সাবসিকুয়েন্ট রিপ্রেজেন্টেশন
অর্জুন
Yes, what is your case?
My lord, on the basis of this complaint, my lord, FIR has been registered by the police authorities, and my lord, the private respondent has obtained bail from the judicial magistrate also, my lord.
or may I submit the police report also?
Not
Already
only this, my lord.
FIR has been
I am-
registered.
What you are praying for?
My lord, I am praying for protection of my life and asset because I am not able to
What
enter
protection
my.
already bail has been obtained by the
No, no, my lord.
by the private
That
respondent.
protection is
If you are agreed by if you are agreed
no,
so
no,
for
no, no.
obtainment of bail
No,
is
no, no, no.
concerned,
Bail is
in that
granted, my
event,
lord.
file an application for cancellation of bail.
No, 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 my lord. Cancellation of my lord. I am praying before your lordship. I can leave, my lord, leave there peacefully because that protection is required.
My lord, the
My
private
lord, because I am being a teacher, assistant teacher, I am, my lord, residing outside my premises. That is the
Annexure
whole
B,
problem.
Annexure B to
And
this
padlock is there, padlock is there.
the
my lord,
FIR.
don't
Copy
die.
of FIR. First one is
If I
GDN.
enter, they will, my lord, severely, my lord, take steps.
Annexure
But
B.
he is alleging that he has not been able to stay at his residence.
Well, so far,
Please wait. You have made your submission.
Lordship.
He has not been able to stay at his residence. Whenever he goes, he is prevented from staying at his residence.
But this is absolutely civil disputes.
No, no.
Internship,
FIR has been
brothers and
registered.
sisters.
Investigation is going on.
Yes, still
Accused
investigation
person
is
on
going.
bail.
Yes.
Now they are preventing the petitioners to stay at his residence.
But to that effect, when subsequent report if it is required, when
I will direct the police authority to provide protection if occasion so arises.
So that I can.
Why you are opposing?
my lord, the petitioner does not live in that
Why you
house.
are
My lord.
opposing? If you do not do anything, then you should not oppose this.
My lord, the petitioner does not live in his parental house. My lord, kindly see, my lord, the order, my lord, order of the civil court, my lord. My lord, kindly see, my lord, order of the civil court.
order of injunction
my
is
lord,
there.
my lord, kindly see, my lord.
See the position.
Yes.
They are also the owner.
Now you
of the
will
house.
be able to understand.
My lord,
As in the order.
my lord, page 17, my lord. This is the order of the civil court, my lord. Page 17, my
Court
lord.
granted injunction.
No.
That effect?
My lord, by that order, my lord, the civil court has declared that the petition, the private respondent number 4 is the owner in respect of the property, my lord. My lord, kindly see, my lord, this is the order, my lord.
Very well. If that is the order, if that is not being complied with, you file an application under order 39 rule 3.
But my lord, the petitioner does not live in that house, my
and
lord.
one section
My lord, he is
151
entering.
CPC.
My lord, he is trying to enter in this house, my lord.
Take steps for implementation of the order of the civil code. But why petitioner will be prevented from staying at his residence?
But he does not live there, my lord. He is entering to it.
Where is the order? of the civil
Page
code?
18.
Show me the order.
Page 18, my lord, your lordship. At the
My lord, page 21, my lord.
Page 21.
we are the pro forma defendants.
One.
Suit is decreed.
Yes, my lord. 21, my lord.
That is not
Paragraph, my lord, paragraph second, my lord.
Page 22 is the order. Just
Operating
Yes.
part is 1020.
misleading your lordship, my post office is there. Post office is the
It is
defendant.
30th January 2017.
Yes, my lord.
order.
Yes, my lord.
Post office is there.
This is the decree of the civil court, my lord.
Old order.
Yes, my lord.
Page 18.
If that is not being, if this order is not followed, in that event, put this decree into execution.
Page 18.
My lord, I am in possession, my lord, peacefully possession, but all of a sudden, my lord, the petitioner is trying to enter into the house, my lord, which is in the possession of the private restaurant, my lord.
Your lordship kindly have
Right
a
of the, right of the petitioner is decided here.
My lord, by this writ petition, my lord, the petitioner is trying to create his right, my lord.
Let me say, post office is the defendant, my lord, 10 and 11. So I am not paid.
You are not defendant there.
Former respondents, it has been admitted by the court.
Now,
my
in
lord.
the suit, you are not defendant.
We are the pro forma defendants and we are admitted as the owners of the property. Your lordship, kindly have a look, page 18.
It says that defendants are restrained.
We are the pro forma plaintiffs. And page 18, my lord, you have said, your lordship, defendants is the post office.
Issue.
Post office is the defendant. Page 18, my lord, at the top.
My lord, at page 21, my lord, it has been decided the plaintiff has been able to establish this title.
Petitioner is taken on record. Stop.
Sir, यही तो हम सर कोर्टेर order ना ना कोर्टेर order पूछी sir.
To provide protection so that petitioner can stay at the premises in question.
আপনি এটাকে চ্যালেঞ্জ করতে পারতেন সিভিল কোর্টে রিট কোর্টে এসে রাইট ক্রিয়েট করছেন.
It is submitted on behalf of the petitioner that he has right to stay at the residence in at the premises in question, which is being prevented by the private, which is being prevented by respondent number by the private response. And petitioner was physically assaulted and threatened to that extent on 4th June 2026. Stop. Next paragraph. Learned advocate representing state respondents has filed a communication dated 14 July 2026 of officer in charge Murutia police station. Court of কি বললাম? Officer in charge Murutia police station, and same is taken on record. Copy of the said communication, copies of said communication are made over to the learned advocates representing the petitioner and private respondents. Stop. It is disclosed in the communication that based on complaint lodged, a criminal prosecution being Murutia police station case number 183/2026 dated 21st June 2026 was initiated and investigation is going. Next paragraph. Private respondents are represented by learned advocate. This suit was at your instance. You instituted the suit.
Yes, my lord.
Please keep quiet. I have heard you. Permit this court to dictate. কি বলছিলাম?
আরেকবার বলো।
Land advocate who submits that issue involved in this writ petition is civil in nature and in support of same relies upon decree of civil court dated 30th January 2017, whereby defendants in the suit were restrained from obstructing the from disturbing the petitioner in peaceful in enjoying peaceful possession whereby petitioner plaintiff over the suit property. Next one. Having considered the respective submissions made on behalf of the parties, it appears that final order was passed by civil court on 30th January 2017, thereby restraining the defendants from disturbing peaceful possession of the plaintiff over the suit property. So on behalf of petitioner, nothing is shown which comes in which fortifies his right over the premises in question. So, however, it is made clear that court is not deciding inter right of the parties over the premises in question. Stop. Police authority is not the appropriate authority to decide right of the petitioner over the property in question. Stop. However, from the communication filed on behalf of the police authority, it appears a criminal prosecution being Murutia PS case number 183/2026 dated 21st June 2026 was initiated, concerned police authorities are directed to take expeditious steps to complete the investigation and submit report before the jurisdictional magistrate. Next paragraph. Police authorities are also directed to maintain peace and tranquility at their local and to see that no untoward incident takes place. Writ petition stands disposed of. Arjun Jalak certificate could be. Next.
Well, these communications are maybe kept on record.
Has been stated by the my lord, page 18 at the top by the landed judge, my lord, that civil court has admitted that I am one of the owners.
That I have not decided here. I have clarified. That the right of the parties over the property is not decided here. Only I have referred the decree passed by the civil court on the suit filed by the private dispute.
That is against my lord, the post office, my lord.
Call the next matter.
Your lordship has
Item number 14.
I am for the respondent number 629, my lord. My lord, I am for the petition. Unfortunately, my lord, in the earlier writ petition, the writ was dismissed with a liberty to file afresh. And what they did, they made a copy and xerox of the present one. And everywhere in the body of the present writ petition, respondent number 629 is there. Everywhere. That means my client. But cleverly, they deleted our name from the constitution. My lord, kindly see the
Very well, let me hear the matter.
My lord, I
If
am
your
praying for
presence
not-
is required, court will consider it.
for-
Yes.
My lord, I am praying for not today as senior is not well today. I am praying for not today.
Why?
My lord, senior is not well today. He is not there in the.
Who is your senior?
I am led by Mr. Mohammed Zoeb Rauf.
Where is he?
But he is in the house today.
Taking rest at home? Yes. And court will adjourn the matter.
My lord, kindly see page 4.
Just a minute. You are not party. You have made your submission. Let me go through the petition. Wait. Not today.
My lord, affidavit.
একটা লাইন ইয়ে করো তো। At the time of call, accommodation is prayed for on behalf of the petitioner. এই দাও তো দেখি। Accommodation is prayed for on behalf of the petitioner on the ground of learned advocate. You are for the state. However, state respondents are represented by learned advocate. Next paragraph. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 11th August 2026. Next, however, it is made clear that no further adjournment shall be granted on the next date. Next.
My lord, may kindly be respondent number 6 to write.
You are not party, sorry. Yes.
Item number 15.
15, I am for the state lordship. No one is okay.
At the time of call, no one appears for the petitioner and no accommodation is paid for. However, state respondents are represented by learned advocate. Stop. Writ petition stands dismissed for default. Parties to act on the server copy. Next.
Item number 16.
16, I am praying student.
Why?
Lordship, I need to engage a senior on my client's instruction. I need to engage a senior on my client's instruction. Lordship,
But we
kindly
have
give me just
already-
one day time.
We have taken.
Fine, Lord,
Happening for whom?
for the private respondents, Lord, it is for registration of an FIR. Lord, they have already filed an application under section 156(3), which is I think 175. That application is coming up for hearing on Friday.
That's regarding a different cause of action. Only one day's time we got to appoint a senior. Taken up tomorrow. We are otherwise ready. Only one day's time.
This matter was adjourned by your lordships earlier.
Previously.
On 21st July.
So how long it will be adjourned?
21st July was that
Several matters were taken up on 21st of July.
Really one day's time.
No, since your prayer is for registration of FIR and already an application under section 175(3) is pending, why this writ petition will be entertained?
That 156(3) is regarding a different cause of action. That's a case of forgery.
No, my lord.
You are appearing for?
I'm for the state, my lord. I'm led by the learned additional advocate general.
My lord,
My lord, there are two separate two earlier cases, my lord. It has been charge sheeted. Court has taken cognizance, my lord. Now there is a representation in form of a complaint which is appearing at page 221, my lord. They are seeking, their allegation is it has not been taken into consideration for registration of FIR. My lord, we are covered by your lordship's judgment, my lord.
But there is a settlement signed by the parties. Parties have acted on the settlement. They have paid 3.5 crores. This
They have
was an
obtained
employee
bail.
of this company.
They have obtained bail on the basis of that settlement, my lord.
It's not required to enter into this issue.
Exactly.
Since your prayer is for
registration of an
FIR.
FIR.
So how that is maintainable?
No, my lord, we say that within the precincts
My lord,
of
will kindly take your. I'm relying on your lordship's judgment, my lord.
My lord, kindly allow me one day time, my lord. Only one day's time accommodation.
No, time. Shit time.
My lord, the agreement that
Where is at page 55, 56?
I am on page 55. Issue. Matter is heard in presence of the learned advocates representing the petitioner. Petitioners, state respondents.
Honorable kindly once
and respondent numbers 6 to 10. 6 to 10.
6 to 10.
Stop. Oh, you are appearing for the
Lord, we appear for the co-respondent 6 and 8. Lord, I appear. He is appearing for 7.
respondent number 6 to 10. Stop. Next paragraph, on perusal of the writ petition and the prayer couched therein. Prayer couched therein. It appears a mandamus is sought for, directing the concerned police authorities to register.
Lord, against police officers only, my lord.
A separate criminal case.
My lord, this is a case of extortion against police officers within the precincts of Lal Bazaar.
My lord, I strongly object, my lord.
That is
I strongly object, my lord. The records of this court speaks otherwise.
Let an investigation be conducted. That is why, my lord, we have come up. Exactly, my lord, we'll see the MOU. My lord, we'll see the MOU.
Encashed in April.
April, exactly. And in March.
She withdrew her complaint, which was made to the Women's Commission.
And you have already filed an application under
No, my lord, regarding 156(3) is a very different cause of action. It's a forgery case. This is an extortion case, my lord. My lord, let me.
Forgery and extortion is.
My lord, I am a victim of a sexual assault case, my lord. That is going on.
Only one thing, my lord. Cognizance has been taken already with regard to the 2 FIRs by the jurisdictional court. So, my lord, by virtue of Nita Singh's case, my lord, the writ court.
This is a different cause of action.
Sir, you have exhausted yourself. Just a second.
Charge sheet file cognizance.
Yes, in both the FIRs.
Those are different cases.
And in so far as the other aspect is concerned, the very basis of grant of bail was on the prayer that on 2 dates in March, once payment was made and once articles were returned pursuant to an internal agreement between the parties, my lord. So that is there. That is recorded also in the order to the
My lord, the internal agreement is the one we sought to challenge, my lord. We say that the internal agreement was forcefully made. My lord,
kindly takes this order, my lord.
The internal agreement, there is nothing in our favor. We say that we will pay money.
There are 2 criminal prosecutions where
both cognizance taken. Both
investigation is complete.
Yes.
Where are these criminal prosecutions?
My lord, I have given the orders depicting, my lord, that cognizance has been taken.
I'll give your lordship.
That is his prayer. That is his prayer also. Kindly takes, my lord, prayer B. Transfer investigation of Koraya PS case number 297 of 24
ওইটা দাও
to the CID.
চার্জশিট যে ফাইল হয়েছে ওটা দিয়ে দাও ওই বাঞ্চ থেকে দাও
297 আর 220.
And also the proceedings of Koraya Police Station case number 228 of 2024.
Now, my lord,
So, my lord, kindly now.
In both the cases, charge is filed.
Yes.
Cognizance taken.
Yes, cognizance taken. I have handed over, my lord, the order sheet, my lord. My lord, kindly appreciates, my lord, Nita Singh's case. No,
my lord will kindly come to
yes.
221, my lord.
Nita Singh. No, Nita Singh.
My lord, different set of accused.
Kindly appreciates the view of the Honorable Supreme Court, my lord. Nita Singh's case.
Those judgment.
Yes.
My lord will kindly see 221 page once, my lord.
Of course.
তাহলে বাকি কি রইল? তা আমাদের কি আছে?
My lord, I have been forced to withdraw a sexual assault case, my lord.
Stop. That to charge has been submitted.
Correct.
There is prayers.
Think about the coercion that I've been subjected to.
File your case for transferring.
So say that file my case. That is why I have come up before this court.
That you cannot. To other.
Parallelly, you can't choose for a.
Karaya Police Station case number 297 of 2024 dated 23rd December 2024. And Karaya Police Station case number.
Correct.
228 of 2024 dated 29 September 2025. Next slide. It is submitted on behalf of state respondents and private respondents that in completing investigation in aforesaid two criminal prosecutions. Charge sheets were filed and court below has taken cognizance of offence.
Wait.
Stop. Next paragraph. Since court below has taken cognizance of offence in connection with aforesaid two criminal prosecutions.
Well, this is a different case, my lord.
Writ petition at this stage of the criminal prosecution is not maintainable, since this court is not considering applications under Article 227 of the Constitution of India, nor an application under Section 482/520 under Section 482 CRPC/5 Section 528 BNSS 2023. Stop. Once judicial order intervenes in a proceeding, propriety of such order ought not to be taken into consideration in a writ petition. Therefore, writ petition in connection with Karaya Police Station case number 297 of 20.
My lord, this is not what we pray for, my lord. We pay for 221, page 221 to be paid.
And Karaya Police
It is an
Station case
FIR.
number 228 of 2024 dated 29 September 2024 are not is not maintainable. So in this regard, reliance is placed on the judgment of the Honorable Supreme Court reported
Yes, completed.
in 2024 SCC Online SC 5761 within bracket Nita Singh and others versus State of Uttar Pradesh and others. Next paragraph. However, it is attempt has been made to demonstrate before this court that there is another issue based on which complaint was lodged.
Exactly.
But the same has not been transformed into an FIR. Compelling the FIR, as a result whereof approach is made to the jurisdictional magistrate under Section 175.
No, my lord, we have not made an approach to the jurisdiction magistrate.
They have not.
We have not. We have not.
So they are now wanting your lordship
to pass an
stand the
FIR.
FIR. That
That
your
is
lordship cannot.
Only complaint lodged.
Yes, ma'am.
Yes.
Yes, ma'am. 221 is the complaint.
So he has a remedy under
Mr.
175.
Kaur has submitted that.
I think they
For
have.
that,
No. Sir, that is a
Mr. Kaur has submitted that
different FIR.
175 application is pending.
That is a different FIR, my lord. That is a FIR regarding forgery. This is an extortion FIR.
No, they have not filed 170. They have a remedy under 170.
Exactly.
So that they exercise.
Yes.
Ali Padamsi will come into play.
Yes.
Yes.
Ali will come into play. Either way,
These kind of matters these days, he is absolutely up to date, which is going to do what.
What they are trying to create is a defense against the case we
Especially
have.
technical issues.
No, not exactly. We have
Yes,
got the
that is all.
audit. We have got the final audit report which doesn't show any loss at all.
So
We
that
have
is your
compensated for the
defense.
loss.
They have a remedy in law.
We have taken 3.5 compensation.
Yes.
For a loss that doesn't even exist.
Human নাকে সর্ষের তেল।
That doesn't even exist in your accounts.
The mandamus is sought for, thereby
It is sued for
directing the
recovery.
concerned police authorities to
That we will do, but the amount
take
needs to be freezed as well.
cognizance of such FIR, such complaint and draw of take cognizance of such complaint and draw of FIR. Stop. In this regard, stop. There is an alternative remedy available to the petitioner under Section 175(3) BNSS 2023. If complaint of the petitioner is not taken note of by drawing FIR. In this regard, reliance is placed on the judgment of the Honorable Supreme Court reported in
Ali Padamsi 2007 volume 7 na 8 Ali 7
ইনফ্যাক্ট জজ সাহেবের অর্ডারটা দিয়ে দিয়েছে।
জজ সাহেবের order।
হ্যাঁ ও আচ্ছা ওই অর্ডারটা তো আছে
2026 SCC Online SC 798 Sujal Bishwas Attawar and another versus State of West Bengal. Stop. Next paragraph.
ওটাই তো নিহারিকা আছে
Hence, present writ petition in view of availability of alternative remedy is not entertained and same stands dismissed. However, this order shall not preclude the petitioner to approach jurisdictional magistrate in pursuit of remedy. parties to act on the server. Much obliged.
My lord, matter is disposed of, my lord.
Dismissed.
Kindly dismiss it, my lord, yes.
My lord, I will.
Wait for cost, my lord.
Absolutely
Not doing
before this.
That will be a wrong order. Since there is an alternative remedy available, I have recorded that I am not entertaining this writ petition, and that's why it is dismissed.
Grateful to you.
That's why it is dismissed.
Item number 17.
This is the unfortunate mother is the petitioner, 86 years old. This is the evidence certificate.
Yes.
Lordship, the petitioner is the 86 years old mother, lost her husband 2015, and father's business has been given to the son. 2019, son and his family started physical and mental torture and stopped supply food, cloth, and medicine, everything.
No, who is before this court?
Now the grandson, on the grandson.
Grandson?
Yes, yes.
Has come before this court praying for
No, no. Now the petitioner. Petitioner means mother.
Grandmother.
Grandmother. Grandmother.
Grandmother has
Grandmother,
approached
yes, Lordship.
against grandson.
Yes.
Praying for what?
Praying for Lordship, they have, on the basis of the order of the Master, my Lord Justice Mantha, Lordship, kindly come to page 21, Justice Mantha's
Order will come later. What you are praying for?
Praying for, they have left the house, but locked
Who
the...
has left the house?
The son...
Whose son?
My
Petitioner's
son, my son, yes, yes. My son and his family left the house, but locked the...
So grandson has a son?
No. My son, his wife, and his...
I thought grandson has a son.
No, no. On the basis of the order of the my Lord Justice Mantha, my son, he's left
Order of the coordinate bench will come later. Please place the facts so that court can have a grasp
Yes,
of
yes,
it.
yes, yes, certain.
Place the facts.
So after that, on the basis of the order of the Mantha, they have left.
After that means nothing is
I'm just
so that court can consider this.
Earlier the son and he's left the court. Now
who left the courts?
Left
the premises. Son
and his wife and one son. But second son, he was sometime in the first floor. Now he was also left, but locked the key, locked the first floor and staircase. So now just present, Lordship, due to rain, the first floor is accumulated by water. And from the concrete, sleeping concrete, water is coming from the ground floor. My gate to
Still it is not clear to me. Where is your complaint? Where is your complaint?
No, sir, page 28, 88, representation.
Page 28.
No, 88. Last annex, Lordship. The pair D is my pair.
So why padlock is put there?
They are staying now at Khidirpur.
Who are staying? Private respondents.
Private respondent. Staying with his mothers at Khidirpur. But due to padlock has been in the first floor or staircase.
Where is your right to use first floor?
I am originally I was the owner of the house. Thereafter, when they stop my food mentally and physically torture and stop food cloth, then I gifted the enter to my daughter. He's the private respondent number.
You gifted the property to your daughter.
Yes, and my daughter is now allowing to stay in my till my death.
So who has put the padlock?
The private respondent grandson.
Grandson has put.
Sometimes he is staying there. He has.
So once you have gifted the property to your daughter, you have no right.
I have Lordship, kindly can page Lordship. This is
I am for the granddaughter. I am for the daughter.
By affidavit, he allowed me to stay here.
Who is for the state?
Lordship, I am for the state. Here is
You are
the
appealing for.
report.
Lordship, the private respondent number 3.
Who are there? Who is he? Who is respondent number 3?
Grandson.
Grandson. So why you have put the padlock?
Lordship, there is no padlock. The house is built in a way where every floor is used and occupied by one person. Now, what is happening is the grandson was staying on the second floor. He wasn't being able to go out of the house or come in. The food was having to be reached to the grandson through outside of the window because they have put a padlock on the ground floor. So for security reasons, we also have a padlock outside because of which she can't go to the terrace. So this is how the house is built.
What is his right?
It's a retaliatory measure.
No, it's not.
Once since the petitioner has put padlock at the ground floor.
Lordship, it has been existing forever. It's now that the married daughter has come into the property and is trying to create a rift.
I gifted.
I have heard you. Please don't disturb.
Get full.
We have lived all along in the same house. Now the married daughter has come in. She alleges to have a gift deed. She has filed a suit for a declaration of her title
which has been suppressed in the writ petition. I'm carrying a copy of the suit.
Who has filed suit? Married daughter
Married daughter
of the petitioner.
of the petitioner. To whom?
Your grandson.
I am the grandson. The married daughter has filed a suit saying that I am the owner. She sought for a declaration that I am the owner. Until such time that declaration is passed, I do not know how they can.
Married daughter who has filed a suit is not party to this petition.
She is pro forma respondent number 44 is here, represented by my learned friend.
Yes, my lord, I am for the daughter.
They have completely suppressed the existence of the suit.
No,
They have sought for an injunction order over there. That was rejected. They went up in appeal. Ultimately, they withdrew the appeal. Now, since they haven't obtained an order of injunction, now they come here.
Why? What?
No, no, no.
authority will
See,
do?
my daughter has filed a civil suit. I have not.
In our report also, Lordship.
Lordship, kindly see the page 15. I shall live there improperly. Water is coming through the first floor.
My lord, I am not
Concrete.
living at the premises, my lord. I am living with my husband at Holdia, my lord. My mother is living there. And not only that, my lord,
Wait.
And
Yes. এক সেকেন্ড রাখি বলে দিন একটা ছবি নিয়ে নেবো
Suit was filed by the daughter.
By the daughter.
Yes. But in favor of daughter, property is gifted.
That is what is alleged. That is what it is. I'm carrying a copy of the printed copy to the. I've carried a copy of the plaint.
Deed of gift not executed in my favor.
You are representing the daughter.
Yes, my lord.
So the gift was executed in your favor.
In my favor.
So why you have filed suit? What you are claiming for?
My lord, since the daughter-in-law and the grandson was not left the house premises, my lord, the petitioner approached before this honorable court, coordinate bench passed order directing the police authority.
That I have seen. What you have prayed for in your suit, if the property is gifted to you.
Title of the suit.
They have locked.
Since they have lost.
At page 12, prayer 1, a decree for declaration that the plaintiff is the sole and absolute owner in respect of the schedule mentioned property and has every legal and fundamental right to use and enjoy her exclusive property peacefully and uninterruptedly. He sought for a decree and a declaration that she is the owner.
My lord, since the private respondent number 3 and the son and daughter-in-law, my lord, disturb the possession.
So at one side, grandson, son, and daughter-in-law, and on the other hand, petitioner and her daughter.
That is the
division.
What they did was every now and then they file a police complaint and come to the writ court. Unfortunately, on the earlier stage, the writ court passed an
But
order
as per order of
directing
this
eviction.
coordinate bench, my lord, they left the house.
It's an incorrect
They
order.
are residing separate premises, my lord.
Affidavit service filed on behalf of the petitioner is record. Next paragraph. Petitioner, by presenting this writ petition, has paid for direction upon the concerned police authorities, which would permit the petitioner to have access to the first floor and roof of the premises in question, with the assistance of the police authorities. Stop. It is next stop. It is submitted that son and grandson of the petitioner have put padlock in a way in the premises which denies access of the petitioner, who is staying at the ground floor of the premises, to upper floors and rooftop. Stop. Next paragraph. You are representing respondent number
3, my lord.
Respondent number 3 is represented by learned advocate. who has opposed this, who has opposed this writ petition on the plea that a suit being titled, on the plea that a title suit being number 1524 of 2022 instituted by daughter of the petitioner is pending before the civil court, and petitioner and plaintiff therein has failed to obtain orders as prayed for. Stop. Next paragraph. Learned advocate representing state respondents has filed a communication dated 12 July 2026 of officer in charge, Vihala Police Station, Kolkata, and semi taken on record. Copies of said communication dated 12 July 2026 is made over to the learned advocate representing the petitioner. Stop. It is also disclosed in the communication that suit is pending before the civil court at the instance of daughter of the petitioner, and issue involved in this writ petition is civil in nature. Stop. You are representing respondent number 4. Respondent number 4, being daughter of petitioner, is represented by learned advocate who supports contention of the petitioner. Stop. In addition thereto, it is also submitted that property that the premises in question is gifted by the petitioner to the respondent number 4. Stop. Next paragraph. Having considered the respective submissions made on behalf of the parties and taking note of pendency of aforesaid title suit,
on submission being noted, my lord,
petitioner needs to approach civil court in pursuit of remedy. Stop. Police authority is not the appropriate authority to decide whether steps taken by son and grandson of the petitioners thereby deny access to the petitioner to the first floor to the upper floors of the premises, including rooftop, is appropriate or not. Stop. Hence, no relief is granted in this writ petition and same stands dismissed. However, this order shall not preclude the petitioner to approach the appropriate forum.
I am only wanting the clean of water, nothing else. That is not in the suit, lordship.
on thing be noted, my lord, the private
police authority will enter into
the private respondent number 3 is not.
Lordship, only clean the water. Otherwise, I cannot sleep there, lord.
Item number 18.
For this matter, I beg the private respondent number 5, 6, and 7. That the petitioner is the owner of 2.5 decimals of land.
Yes.
Petitioner is the recorded.
You are appearing for the state.
No. I am appearing for the private respondent number 5.
Who is appearing for the state?
On earlier occasion,
How you have served?
I have served.
Bring it out of this.
Earlier occasion, my lord, an advocate appeared for the state. That the petitioner did not appear.
Where is the original copy? So for acknowledgement of government leader is concerned.
The main affidavit of service.
Yes.
Therefore, main affidavit of service, my lord, I have lost, my lord, from my table. Therefore, my lord, I have collected the, my lord, from the Xerox copy.
Who is appearing for state, Mr. Maiti? Who is appearing for state?
Could you please take a short pass over on behalf of Mr.
Oh,
Loknath Chatterjee?
I am sorry, Mr. Loknath Chatterjee is appearing in this matter. Lordship, he is here.
Oh, I am for the private respondent.
Yes.
The petitioners are the owners of 2.5 decimals of recorded owners of 2.5 decimals of land. That the land of the petitioners is well demarcated with the private respondents. And in spite of that, private respondents might not repeatedly attack the petitioners and might not disturbing the position of the petitioner.
Podesha. Disturbing petitioner's Podesha. So the police will decide.
No. Land
and demarcate the land in question.
Land is well demarcated. The petitioners, predecessors in interest also sold some portions of the land to the private respondents.
What is your submission?
My submission is that is the land dispute, my lord. They have suppressed the fact
my lord, the younger son of the petitioner, my lord, sold some properties to the, my lord, the private respondent, my lord. Private respondent was 7 is the, my lord, daily wages laborer. He has come from, my lord, cutting the grass. My lord, they have falsely, my lord, implicated in that, my lord, that complaint.
So you are not disturbing the possession of the petitioner.
They have asked for the unauthorized construction, my lord. In one petition, my lord, one time unauthorized construction and another, my lord, police inaction, my lord. Can you see the prayer?
Unauthorized construction.
Can you see the prayer?
My lord, just to cut it short, my lord, it's basically a land dispute. The petitioner's father-in-law had given the land, my lord, to some of these apart people. Then dispute started amongst them. Ejmali land, this land, that land. Absolutely, my lord, a civil land dispute. Yes. My lord, this is what, my lord, the police have also, my lord, and also, my lord,
They have, my lord, preferred an application.
basically a demarcation dispute, my lord,
to the
of the land.
subdivisional magistrate. We have, my lord, given the, my lord, the keep peace bond.
No, annexer P2, my lord, that is well demarcated. And thereafter, my lord, petitioner filed complaint against the private respondent, my lord. They have looted away the trees lying upon the plots of the land of the petitioner. Hence, my lord, petitioner appeared several times before the officer in charge of the police station and, my lord, tried to lodge complaint, but the police officer refuses. Hence, my lord, she sent a complaint.
Kindly see the prayer B.
Matter is affidavit of service filed on behalf of the petitioner is taken on record. Stop. Petitioner's court. It is submitted on behalf of the petitioners that their land, the possession of submitted on behalf of the petitioners that possession, their possession over the land in question ought not to be disturbed by the private respondents and direction is sought for which facilitate the petitioners to have peaceful possession over the land in question. Stop.
And 20.
Direction, stop. Direction is also sought for which would prevent private respondents from making any unauthorized construction. Stop. Next paragraph. Learned advocate representing private respondents and learned advocates representing private respondents and state respondents have opposed this writ petition on the plea that issue involved in this writ petition is civil in nature. Stop. Next paragraph. Having considered the submissions made on behalf of the parties, it appears that petitioner prays for direction which will prays for a direction which will facilitate the prays for a direction upon the concerned police authorities which will facilitate petitioners to enjoy peaceful possession over the land in question. Stop. If petitioners find that their right over the land in question is being impacted by the private respondents or other parties, in that event, petitioners need to approach appropriate forum in pursuit of remedy. Police authority is not the appropriate authority to decide the right of the petitioners over the land in question. Next paragraph. Hence, present petition is not interfered with and same stands dismissed. However, this order shall not preclude the petitioner to approach the appropriate authority if so advised. Petitioners could be. Mr. Chatterjee, take it back. I have not relied upon this. Next.
Yes.
Item number 19.
Yes, my lord. May it please your lordship, my lord, this is the
19, Lordship, I am led by our learned AAG, Mr. Rajdeep Majumdar. Lordship, I am only seeking for a day's accommodation.
well, there's only one issue.
And for the private respondents.
I don't have a problem. The only thing is that your
দিয়ে দাও
lordship
তো দিয়ে দাও আজকে কোনো order হবে
might, because my lord, there is a chart which we've already presented. And my lord,
They'll come back tomorrow.
they can give a comprehensive report.
When you will come back, Mr. Banerjee, tomorrow, you on your behalf also time is prayed for. Not today.
I'm not opposing.
and never before your lordship.
Yes, yes.
Item number 20.
It will retain its position.
20, my lord, in this matter, learned AAG below the literature in this matter, my lord. We need to take instruction, my lord. I'm praying for 1 week time.
After a week. Any urgency?
Your Lordship, just that what it concerns is a quashed FIR and the documents seized therein. I'm unable to produce or rely upon them in a pending civil suit. So that is the only urgency that I have.
Then you can wait.
Within 1 week, Your Lordship will
At the
kindly
time
take
of call, accommodation is prayed for on behalf of state respondents to obtain instruction. Stop. Hearing of this matter stands adjourned. List the matter. Next at a sentence. Petitioners are represented by learned advocate. Next paragraph. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 6th August 2026.
Very good.
Great.
Obliged.
I am for the statement. I am for the petitioner, my lord. The bank is also a party. It has been served. My lord, upon my complaint, an FIR has been registered way back in 24th March 2025. Now, what the incident happened? I am the owner of a property. Using my PAN and Aadhaar card, some miscreant, my lord, applied before the Bandhan Bank for a loan, which was rejected. And I was informed from the branch itself that this is what happened. I immediately lodged the FIR and it was registered. They issued me a notice under section 94 for deposition of all my relevant documents and I complied with the same. During pendency of all these things, no progress as per my knowledge has happened. In the meantime, subsequently, the same Aadhaar and PAN card using different again the same photograph which was in the Bandhan Bank, another loan application was forwarded before the Indian Overseas Bank, Teghoria branch. And from there, a loan has been sanctioned. Subsequently, I was informed from the bank that a loan has been sanctioned in my property. One of the person declaring himself as the purchaser and the vendor is photographed doesn't match. Now, the interesting part is that I am having a account in Indian Overseas Bank at a different branch. So my details are in the system of the Indian Overseas Bank. Still, using my Aadhaar and PAN having different photograph, the loan has been issued. The same thing was informed to the same police station under the same FIR. Till date, nothing, no progress has been informed to me as.
With regard to progress made in the investigation in connection with which police station this is?
Koraya police station. My lord, anything, the third fraud may happen.
72 of 25th of March 2025.
Yes, ma'am.
If you are dissatisfied, then you have to approach the jurisdictional magistrate. High Court will not pass any order.
Well, it has been registered.
After registered, if there is no progress made or there is inaction on
But
the
I have
part of the
complied with section
concerned police
94.
authorities, then remedy is not approaching writ court under Article 226.
My lord, I understand your lordship view. I understand, my lord. But one thing, in the meantime, if the third fraud happens, then I am in a soup totally. Already second fraud conducted.
The petitioner is taken on record.
My lord may give some safeguard to me.
My lord, now for the private respondent number 5, lordship.
The bank is not appearing upon service.
A case
My lord,
is
I'm here, my
on
lord.
behalf of the petitioner that though an FIR has been registered and a criminal prosecution has commenced, being Koraya police station case number 70, it's Koraya, it is not stated in this. Where is your FIR?
Yes, my lord, it is at.
Where is the FIR?
Page 15, my lord. This is the complaint.
My lord, I am for the respondent number 5, my lord.
No, I am asking for an copy of the FIR.
The page 82 contains the details of the FIR.
82 notice under section 94 BNS.
And that contains the.
Yes.
Yeah.
Right.
My lord, I'm for the respondent number 5. My lord. My lord, I'm for the respondent number
Yes, I
5, my
have
lord.
heard you. It's not, you are
Yeah.
not called upon to say anything.
Lordship,
Your
lordship.
name
I'm
will be
Lord.
recorded. Yes.
Lordship, lordship.
Yes, Kora Police Station, case number 72. Kora Police Station, case number 72 of 2025, dated 24th March 2025. The 25th matter, but no steps have been taken by the concerned police authorities by taking forward the investigation to its logical conclusion. So prayer is made in this writ petition, directing the concerned police authorities to take expeditious steps to complete the investigation. Next paragraph, state respondents and respondent number 5 are represented by learned advocates. Next paragraph. You are for the bank authority.
Lordship, I'm for the bank. Indian Overseas Bank, lordship.
If petitioner is dissatisfied with inaction on the part of the concerned police authorities in investigating aforesaid case, in that event, petitioner needs to approach jurisdictional magistrate under section 175(3) BNSS 2023. Stop. In this regard, reliance is placed on the judgment of the Honorable Supreme Court reported in 2026 SCC Online SC 798, Vishwas Attavar and another versus State of Maharashtra and others. Stop. In paragraph 7 of Sujal Vishwas Attavar Sutta, it has been decided that in the event party is dissatisfied, and that in the event it is decided, or it in paragraph 7 of Sujal Vishwas Attavar, it was held having if a person has a grievance that his FIR has not been registered by the police, or having been registered, proper investigation is not being conducted, then the remedy does not ordinarily lie in invoking the writ jurisdiction in the first instance, but in seeking recourse to the statutory framework, unless, of course, the urgency of the circumstances warrant otherwise. Stop. Court also relies upon judgment of the Honorable Supreme Court reported in 2008 to SCC 409 within bracket Sakiri Basu versus State of Uttar Pradesh and others, which was relied upon by the Honorable Supreme Court in the while delivering judgment in Sujal Vishwas Attavar Sutta. Next paragraph. Therefore, at this stage, remedy lies before. Therefore, at this stage, petitioner needs to approach jurisdictional magistrate under section 175(3) BNSS in the event investigation is not being carried out appropriately. Stop. Next paragraph. In view of availability of alternative remedy, writ petition is not entertained and same stands dismissed. However, this order shall not preclude the petitioner to take steps in accordance with law if so advised.
Page 84, in the meantime, subsequent fraud has occurred may be mentioned.
Now, that cannot be taken cognizance unless and until police authority takes steps. Next.
Demobilized. I'm taking a leave, lordship.
Item number 22.
I'm for the respondent.
State. I am for the state.
I'm for the respondent.
There is the commissioner of police, but I have not served upon them.
This is my report, my lord.
Yes, keep it with you. I have not called for any report. If I require, then I will call upon.
My lord.
to-
My lord,
Yes.
these 2 and
Ask him.
3 requires to be served.
Approach the jurisdiction.
One prayer. But there is a witness protection scheme of the government, 2018 scheme, in which, my lord, it is the duty of the police to protect the witnesses. My lord, let that be implemented at least. This is my prayer. But investigation, as it is going on, I'm not questioning the investigation.
No, you have prayed for arresting.
Lordship.
Approach the jurisdictional magistrate.
My lord, so far as the witness protection scheme is concerned, that is ensured by the government, and it is the duty of the police to ensure that the witnesses are protected. Let police ensure that. That is my limited prayer. Nothing more, nothing less.
To what extent you are praying for ensuring witness?
Because, my lord, it is a matrimonial dispute. Lordship has seen 85-80. She is a lady. Now, my lord, only thing is, my lord, she is being pressurized by the private respondents to withdraw the case. My lord, let police ensure that she is protected.
But, that means the accused persons are on bail.
No, my lord, accused persons are absconding. While absconding, they are, my lord, asking her to withdraw the case. My lord,
Where you have, how you have approached upon the police authority before
lord,
the
kindly
police authority for implementation of witness protection scheme.
My lord, kindly comes to.
Where is the approach made?
Kindly comes to my complaint at page, my lord, 26, annexure P4.
Yes.
But kindly comes to the paragraph, it is regrettable.
Yes, page 26.
But page 26 comes to the next page, page 27.
Yes.
It starts with, it is regrettable, that paragraph. Insecurity.
That is in a different perspective. This is where is this approach made? That in terms of the relevant scheme, petitioner is entitled to get.
But
benefit
anyways,
of
my
that.
lord, that is a scheme of, that is a scheme of the government. But that is a scheme of the government.
It is afterthought approach.
No, my lord, let me.
I could understand that by making a complaint or representation, a prayer was made or approach was made before the police authority for implementation of the scheme.
No, my lord, that I have stated in my paragraphs.
Having her affidavit of service filed on behalf of the petitioner. Where is your affidavit of service?
Lordship.
Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Learned advocate representing the petitioner prays for direction upon the concerned police authorities to arrest accused persons and take certain other steps in Gaighata Police Station case number 528 of 2026 dated 12 June 2026 under section 85/351 within bracket 2/316 within bracket 2/35 of BNS 2023 read with sections 3/4 of Dowry Prohibition Act 1961. Stop. Stop. It is also submitted that a protection needs to be a protection may be granted to the petitioner is the victim lady.
Victim lady.
Protection may be granted to the petitioner. Stop. Next paragraph, state respondents are represented by learned advocate. Stop. Next paragraph. From the case made out in the writ petition, it transpires that dissatisfaction is expressed regarding manner of investigation carried out by the concerned police authorities in Gaighata Police Station case number 528 of 2026 dated 12 June 2026. Stop. If petitioner is not satisfied with the steps taken by the concerned police authorities while investigating aforesaid criminal prosecution, in that event, petitioner needs to approach jurisdiction magistrate in pursuit of remedy. Stop. In this regard, reliance is placed on the judgment of the Honorable Supreme Court reported in 2026 SCC online SC 798, Sujal Bishas Attapar and another versus State of West Bengal others. Next paragraph. However, a case is made out that petitioner is however, a case is made out that petitioner apprehends threat at the instance of accused persons requiring protection. Stop. Concerned police authorities are directed to provide protection to the petitioner if occasion so arises. Writ petition stands disposed of urgent injunction. Next.
Item number 23.
Your Lordship, I am appearing for the petitioners. Your Lordship, in this matter, pertains to police inaction as the accused, against the accused, respondent number 5. Against the accused,
You have served upon the respondents.
Your Lordship, I have not served upon the respondent as I am praying to move before Your Lordship to withdraw this writ petition as the accused has obtained bail.
Obtained bail?
Yes, yes.
At the time of call, learned advocate representing petitioner submits since accused has obtained bail. This writ petition has become infractious. Stuff. In view of such submission made on behalf of the petitioner, writ petition stands dismissed as infractious. Parties to act on the server.
Item number 24.
Who is appearing for the petitioner? Who is appearing for petitioner?
Item number 24, it is the same.
Same
one.
So why you are leaving court? Wait. The petition accused has obtained bail.
Yes, Your Lordship. Same respondent number 5 in both the petitions.
Petitioner is accused in this in the criminal prosecution.
No, Your Lordship.
একই order করে দাও, same order. Next.
Item number 25.
I am for the statement. Or I am for the writ petition.
6 and 7.
This is our report, my lord, from the police officer.
Wait, I have not called for a report. Don't try to place it. If I require, then I will permit you to file it.
On 16/6/2026, my lord, the accused person attacked me, and my lord, they have, my lord, torn my lord blouse, and my lord, I was beaten by them. But my case was registered. My lord, specific section is 79, that is modesty of woman, has been inserted. But my lord, I have a very specific case before your lordship. The investigating officer intentionally did not seize anything from my lord blouse, and my lord, even medical report, I have my original medical report that has not been seized, and for that reason they got bail. After getting the bail, again, my lord, on 30th, that is page 21, the accused persons came to my house, and I, being a widow, my lord, threatened me. Kindly come to page 21. My lord, I approached to the, my lord, IC Nolhati, my lord, PS, my lord, for protection, and I raised objection against the investigating officer. He is not
an application for cancellation of bail.
Yes, I will. I already prepared it, my lord. In spite of what is my prayer is, my lord, prayer P.
So, since the accused persons are enlarged on bail,
certainly,
and thereafter they are threatening the petitioner.
Yes.
And petitioner apprehends further ill treatment and misbehavior at the instance of the accused
my lord.
In that event,
Yes,
apply for
my
cancellation
lord.
of bail.
I am ready, my lord. My lord, yeah, I am going to file.
Since the coordinate bench has passed an order granting bail to the petitioner, what this court will
No, my lord.
do?
My lord, kindly come to prayer B. What I am on, my lord, the investigating officer till date, my lord, main thing is seizure. My blouse and even my lord medical report. I have the medical report, my lord. Kindly see that has not been seized. My lord, I want
Affidavit
to
of service
for
filed-
changing my the investigating officer. He is not.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph, it is contended on behalf of the petitioner that certain materials are required to be seized by the investigating officer while investigating Nolhati Police Station. Nolhati Police Station case number 307 of 2026 dated 16 June 2026 under certain provisions of BNS. Stop. It is also submitted that after it is also submitted that accused persons after being enlarged on bail are threatening the petitioners. Stop. Prayer is made in this writ petition for directing the concerned police authorities to take necessary steps for taking the investigation to its logical conclusion at an early date. Next paragraph, state respondents and
Private respondent number 6 and 7.
Respondent number 6 and 7 are represented by learned advocates. Next paragraph. If petitioner is aggrieved by inaction on the part of the police authorities in taking necessary steps, thereby seizing seizing items, in that event, petitioner needs to approach jurisdictional magistrate under section 175(3) BNSS 2023. Stop. High Court, while exercising writ jurisdiction under Article 226 of the Constitution of India, under Article 226 of the Constitution of India is not an appropriate forum for giving direction upon the concerned police authorities to investigating agency to take steps in connection with investigation at the first instance. Unless exigencies demand otherwise. Stop. In this regard, reliance is placed on the judgment of the Honorable Supreme Court reported in 2026 SCC Online SC 798, Sujal Bishwas Attavar and another versus State of Maharashtra and others. Next paragraph. It is also contended on behalf of the petitioner that accused persons on being enlarged on bail are posing threat to the petitioner. Stop. If petitioner finds if petitioner is being threatened by accused persons after being released on bail, in that event, it will be open to the petitioner to take steps in accordance with law for cancellation of bail. Stop. Next paragraph, with the aforesaid observation, writ petition stands disposed of, parties to act on the subject. Next.
Every service be kept with the.
Yes, every service to Nina.
Item number 26.
Lordship, I'm appearing for the petitioner, Lordship. Lordship, the service upon the private respondent has returned as insufficient address, though we have served on the address.
Whether the private respondents are absconding?
No. Private respondent has been the complainant in the criminal case pending. And we have.
Then you have to serve.
I have served on the
complainant.
Lordship, I kindly appreciate. I have served on the address which is available in the FIR only, and the whole envelope came back as.
No, it is your duty to serve. How you will serve, you have to take the responsibility.
Lordship, may I
serve and come back?
Lordship, may I seek for one indulgence, Lordship? Can the police authorities of the state be directed to serve? I'll serve again and I'll come back with an affidavit of service. But if the state is
Learned advocate representing the petitioner prays for direction. Learned advocate representing the petitioner submits that service upon respondent number 4 is not complete.
His grievances already has been redressed.
Redressed. How?
I'm placing it.
Yes, tell me how it is redressed.
He was complaining that he was prevented from taking bail before the learned ACJF. That has been done.
no
Bail obtained.
no,
Yes.
bail obtained, but it's not only about if then
This is the report.
the complainant, the private respondent number 4 is a learned advocate practicing in Barashat court. He has lodged a FIR against
Petitioner is the accused person.
petitioner is the
Yeah.
accused person. Lodged a FIR. Subsequently, I was prevented from obtaining bail. I was enlarged on bail by a coordinate bench of this court. Anticipatory bail was granted to me. My main contention is that the police authorities, in collusion with the private respondent, has been demanding an amount, and I have categorically stated, and I've sent a representation dated on 19th of May 2026. Sent the representation before the authorities. What has happened, that FIR was lodged. Subsequently, this petitioner was called for a settlement meeting, and I have also annexed the phone call records where the respondent number 4
2nd July.
called.
2nd July, he has been surrendered.
Surrendered and obtained bail.
I have been enlarged from and by anticipatory bail, and I have
Service filed on behalf of the petitioner is taken on record. Next paragraph. By presenting this writ petition, inter alia, petitioner has prayed for direction upon the concerned police authority to conclude investigation, to complete investigation by expeditiously taking steps in connection with Barashat Police Station case number 163 of 2026, dated 20 April 2026. Stop. Next paragraph. However, it is submitted by the learned advocate representing the petitioner that petitioner is the accused person in aforesaid criminal prosecution, and on surrendering before court below was granted bail on 2nd July 2026. Next paragraph. Since petitioner was granted bail on 2nd July 2026, present no further order need be passed on this writ petition, and same stands disposed.
Lordship.
Next paragraph. However,
Lordship, my
this order shall not preclude the petitioner to take steps in accordance with law, if so advised.
Lordship.
Next.
Report taken on record.
Call other matters.
Report taken on record.
Not required.
Not required.
I have not relied on it.
চলো আমাকে দিয়ে দিন।
That bail order is there. Give it to my officer. Let me sign the order, and thereafter, if necessary, let it be on record.
Then I am handing over a copy.
Bail
But
order
it is not recorded. It is only for my
Yes, for convenience.
convenience to go through the papers if required.
we have also annexed
Yes.
the same.
Yes.
Item number 83.
Yes, 83 onwards. New motion 1. Come back on the next. But this is my application.
Lordship, item number 83, there was a direction on the district magistrate Purvo Medipur to file a report with respect to the steps taken in terms of an order which was passed in a writ petition of 2024. Lordship, there have been multiple changes in the district administration over there. They are unable to trace out that file. Will require some more time to trace that file out and produce that order.
By which order it was directed, Mr. Das?
It was firstly directed by an order dated 31st of March 2026.
Just you have amended the cost title?
Yes, of course. Page 21, the order, the coordinate order.
Also, your loss is around 30.
So you have to disclose any steps taken by the district magistrate.
Yes, Lordship. Now, the practical difficulty, Lordship, I will say, in their system, it is showing that the file is not pending, but the physical file is it's taking some time to trace out. If my learned friend could help me with the date of the hearing notice which may have been given to him, because this has
Give
not
the
been.
particulars to him.
No, I already
He can track the
all things have annexed here.
status of the case.
All things have annexed here. Every order, everything.
No, even if any other information
No, no,
is
he
required,
he can ask.
and if those information is not available with you, obtain take instruction from your client petitioner and inform the Mr. Das
This is your duty to assist.
so that it will help you to track the present status of the case, because it depends upon the steps taken by the district magistrate. Now, petitioner, learned advocate representing the state has to take the responsibility of informing this court whether any order was passed by the district magistrate or no.
Yes.
So therefore, if
But that one is easier with me, man. I've not got that.
therefore any information which is which will facilitate the state advocate to obtain present status, and if it is available,
If it's
in
available
that
to me, I will help you.
in that event, inform those.
But one thing I one thing,
Time
man.
of call,
Plus-
learned advocate.
plus one
at
prayer,
the
man.
time of call, Mr. Das, learned additional government pleader, representing the state respondents, has prayed for accommodation to file a report in terms of the order dated 31st March 2026. Stop. Petitioner is represented by learned advocate. Stop. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 10th August 2026.
But only one prayer paper.
Yes.
But in the meantime, what I'm this is hooligans, man. We are the Sebites. We have been disturbed. We have been heckled. But they are creating much trouble, man. One
I'll
of
come back, let me
only the police, the Tomlu police will take step, man. If I approach to them, only one order, man.
Come back, please come back. Let me see. Yes.
Grateful. Item number 84.
ভাই কি দেবো বাবা টেন পাচ্ছে বলো সাহেব ইঞ্জিনিয়ারিং বাবু সূর্য নেই সূর্য
হিয়ারিং দেওয়ার কথা ছিল ওই হিয়ারিং নোটিসে যদি মেমো নাম্বার বা ডেটটা দিয়ে দেন না তাহলে ওরা ফাইলটা ট্রেস করতে পারবে
হিয়ারিং নাম দেখবো জিজ্ঞেস করে দেখবো ঠিক আছে ঠিক আছে
Mr. Das, what happened in this matter? Nobody is appearing for the petitioner.
Sealed covered report is there.
That is for employment of
Employment, there were two
on
criminal
target
cases.
category.
Yes, what I've been told, I have not seen the report because it's supposed to be sealed cover. There are apparently two criminal cases pending against the petitioner. I have been told that I have not seen it. I should not be commenting. This has been forwarded to the concerned department also, which is supposed to recruit the petitioner.
I don't want to hear this matter. If possible, I would prefer to hear this matter in presence of the learned advocate.
Lordship.
Today you don't file it.
My lord kindly takes it on record, Lordship. This is a sealed cover report. I don't want to. My lord may go through the report and keep it with the record.
Very. काटो तो That's why police clearance is not being provided to the petitioner.
Lordship, whether the police very clearance has been provided or not, everything is in this report, which I have not seen. report আছে
In one case, charge sheet has been submitted.
My lord, I am not aware of anything, Lordship. This is in the sealed cover.
Let a chance be given since today it is a matter of employment.
Lordship.
Under died in earnest category, subject to police verification and medical clearance.
My lord, my duty is only to get the report before your Lordship. There are two cases, right, Lordship? Yes.
In one case, charge sheet has been. At the time of call, petitioner is not represented by learned. Next paragraph. However, Mr. Shubjanil Das, learned additional government bidder represents state respondents, has filed memo dated 24th June 2026, issued by Superintendent of Police, Ongaon Police District. Forwarded to Deputy Inspector General of Police, Intelligence Branch, West Bengal, Kolkata. Stop. Such memo dated 24th June 2026 is filed in sealed cover and memo is perused during course of hearing. Stop. Memo dated 24th, said memo dated 24th June 2026 is taken on record. Next paragraph. Since petitioner is not represented, learned advocate for the state respondent is directed to serve a notice upon learned advocate representing the petitioner by 7 days from date. Serve a notice. Stop. And list the matter under the same heading for further consideration on August 10th, 2026.
Grateful.
Survey notice. Sৌরদীপ সরকার.
Lordship. The notice দিয়ে দিন। Item number 85.
The petition. Earlier occasion, a report has been called for my FIR lodged by the petitioner against the private respondent in the month of May 2024. Till date, no steps, no arrest, even the charge sheet has also not been submitted.
Yes, Lordship. This is my report. My lord, I can make submissions after my lord goes through the report.
Yes.
I can make the submissions after my lord goes through the report.
May I get a copy of the report?
Yes. Affidavit of service, no. In terms of the order, in terms of the order passed on this writ petition on 10th June 2026, Mr. Das, learned additional government tutor represented state respondents, has filed a communication dated 13 July 2026 of officer in charge Tirupati Police Station, Kolkata, and same is taken on record. Stop. Copy of the said communication dated 13 July 2026 is made over to the learned advocate representing the petitioner. Stop. Next paragraph. It is disclosed in the disclosed in the communication that based on the complaint lodged. It is disclosed in the communication that investigation is being carried out in Tiljala Police Station, case number 192 of 2025, dated 17th May 2025. Stop. If petitioner is aggrieved by inaction on the part of the concerned police authorities in completing investigation of aforesaid case, in that event petitioner needs to take recourse to Section 175(3) BNSS 2023 by approaching jurisdictional magistrate. At the first instance, writ petition is not maintainable before this court due to availability of alternative remedy. So in this regard, reliance is placed on the judgment of the Honorable Supreme Court reported in 2026 SCC Online SC 798, Sujal Vishwas Attavar and another versus State of Maharashtra. Next paragraph. Hence, writ petition is not entertained in view of availability of alternative remedy and same stands dismissed. However, this order shall not preclude the petitioner to approach jurisdiction vested in pursuit of remedy. Next.
Item number 86.
I'm for the petitioner. But on instruction, I'm saying, my lord, the police, as per your lordship direction, never went to the house of the petitioner to make inquiry. My client is here, my lord. I don't know. Your lordship directed.
Yes.
Your lordship directed on earlier occasion.
Just a minute, let me go through my own order. How you have served upon respondent number 6 and 7?
Well, by,
after the order was passed on 24th of June 2026.
By speed post, my lord, they are accepted. The private
Affidavit of service?
that is not ready, my lord.
I directed to file affidavit of service by serving copy of this order upon the respondent number 6.
No, I
and
have
7.
served, my lord. This is the
That will not do. Yes, what is your instruction?
This is the report. What had happened is, Lordship, the petitioner was entitled to Pradhan Mantri Awas Yojana plot. She was making a construction. There was an order under 163 basis which the police has conducted an inquiry. Police has submitted a report. The jurisdictional executive magistrate has directed to maintain peace and tranquility. What basically is happening, Lordship, there's a civil, the dispute is civil in nature where the petitioner is being prevented from apparently constructing house under the Awas Yojana. Now, Lordship, the police are maintaining peace and vigil. But now the police cannot go and start picking up bricks and constructing the wall for the petitioner.
here no permission is required under the Panchayat Act.
I'm not joining issues on that.
I
I'm not at all
base
joining issues on
construction,
that.
only the roof. Kindly see, Malat page 21. Only the roof I want to make Paka construction. Asbestos was there, but due to the Malat passage of time, the asbestos has been broken down. Only the roof.
Construction is complete.
Yes.
Only roof is
Only roof.
23.
Yes,
Nothing more.
Lordship, the police, the duty of the police is to maintain peace, tranquility, and ensure that
Only
there is
the
no law
roof,
and order situation doesn't
Nothing
arise.
more.
Now, the police cannot act as private security guards and stand over there and ensure that the writ petitioner can go and
Really serve notice, another notice upon the private respondent. Let me see. Entire construction is completed.
completed. The roof is
To be.
I don't want to get into that dispute. That is not.
Only a roof is to be constructed.
Yes.
Asbestos was there. I have stated in the petition, but
It is under Awas Yojana.
Awas Yojana.
an asbestos Malat passage of time that has been broken down.
So the private respondents are objecting.
Yes.
What
Their
is their contention?
Their condition, my lord, that I will not allow you to constitute. I do not know why. I do not know. My lord, all the lame excuses, my lord. I am the entitled to get the judge.
Well, serve a notice, let me see. Issue.
Thank you. Only the roof, my lord, and I with my children are living, at present living in a polythene sheet. Polythene sheet, my lord, in this rainy season.
Entire construction with collapsible gate. See page 23.
Yes, my lord. It was asbestos. I have stated, my lord, on oath.
In terms of the order dated 24 June 2026, a communication dated 23rd July 2026 of officer in charge, Mograhat Police Station, Diamond Harbour Police District, is filed today and same is taken on record. Stop. Copy of the said communication dated 23rd July 2026 is made over to the learned advocate representing the petition. Learned advocate representing the petition. Next paragraph, learned advocate representing the petitioner submits that under which Awas Yojana?
আবার ইন্দির প্রধানমন্ত্রী আবাস যোজনা
Under Pradhan Mantri Awas Yojana, petitioner has started construction of dwelling house, but roof of the house could not be constructed due to objection raised by respondent numbers 6 and 7. Stop. Next paragraph, in spite of service of notice, respondent numbers 5, 6 and 7 are not represented. Stop. Learned advocate for the petitioner is directed to serve notice upon respondent numbers 5, 6 and 7, enclosing copy of this order by 10 days from date and file affidavit of service on the next day. Next paragraph. It is made clear if in spite of service of notice, respondent numbers 5, 6 and 7 are not represented before this court, writ petition shall be heard in absence of those respondents. Stop. Next paragraph. Officer in charge, Mograhat Police Station, is directed to cause further inquiry and to disclose by submitting another report as to why after making entire construction, roof of the premises could not be constructed. Stop. Let such further report be filed on the next date. Next paragraph, list the matter under the same heading for further consideration on August 2026. Mr. Das, see.
I will try to find out why the roof is not being constructed.
Investment has been made and a poor person under Pradhan Mantri Awas Yojana.
Understand.
Otherwise, the entire effort will be frustrated after making construction.
I will look into it.
Item number 87.
Item number 87, I am appearing for the petitioner. Deputy
Yes.
of service. Well, the petitioner is the resident of the address given in the cost title, and the police is restricting him from entering into his residential house, my lord.
Who is obstructing you from entering into the
Let
residence?
the police authorities, the earlier officer who was posted in Chapra police station has orally obstructing the petitioner from entering
Not
into
to
his
enter.
house.
Police is saying not to enter.
Not to enter into the house of
your
the
residence.
into my residence only.
Police is obstructing.
My lord.
Yes.
May I make submissions? This person, Lordship, has various criminal antecedents. Now, Lordship kindly looks at the cases which he has been arraigned in.
My lord, he is in bail.
Let me complete it. I will not interrupt you. Second page.
What are
3 and 4 of Explosive Substances Act, 3 and 4 of Explosive Substances Act, 9B of the Indian Explosives Act. I am not getting into the
There
Indian
are 4
Explosives
criminal
Act.
prosecutions pending against the PF.
There are 5
He is in bail, my lord. He is only
Explosive Substances Act.
Nothing else, my
He
lord.
himself doesn't want to come. Why, Lordship? As soon as Explosive Substances Act FIR is registered, the state government forwards it to the NIA. NIA takes over because it's a scheduled offense under the UAPA and the NIA Act, under Section 6 of the NIA Act. He doesn't want to come back.
His residence, my lord.
Not with the help of the order to be passed by the High Court. Sorry.
My lord,
Sorry.
police is not allowing
You
him.
disclose this pendency of these criminal prosecutions in the writ petition?
Whatever I have,
Have you disclosed it that these prosecutions are pending against you? I am asking you.
My lord, I have already stated the GR.
Where you have disclosed it in the writ petition that there are 5 criminal prosecutions pending against you? You are approaching writ court, you should come with clean hands.
My lord, paragraph number 9.
He is aware of a case of 2021.
GR case number, there is a different case.
He is aware of a case which is registered in 2021, but he is not aware of the cases registered in 2019, 2013, 2 cases, and 2003.
Where is the disclosure of pendency of the criminal cases pending against you?
I fault, my lord.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Next paragraph. Petitioner prays for direction upon the concerned police authorities which would permit the petitioner to enter into his residence. Stop. It is submitted that concerned police authority is obstructing the petitioner from entering into his residence. Next paragraph. Mr. Das, learned additional government leader representing the state respondents, has filed a communication dated 30th June 2026 of Inspector in Charge Chapra Police Station, Krishnanagar, and same is taken on record. Stop. Next paragraph. It is disclosed in the in the said communication dated 30 June 2026 that all are under Explosives Act.
Only one is Indian Explosives Act. Indian Explosives Act is not a scheduled offense under the NIA Act. Explosive Substances Act is 3 cases under the Explosive Substances Act, which is referred to the NIA. It is a scheduled offense under NIA.
Residential house, my lord. Nothing else, my lord.
As well as attempt to murder.
My residential house.
কি বলছিলাম? That there are 5 criminal cases pending against the petitioner, out of which 3 cases are under sections 3/4 of Explosive Substance Act. Stop. Next paragraph. Surprisingly, pendency of these criminal prosecutions are not pendency of these criminal cases are not disclosed in the writ petition. Stop. Taking note of pendency of criminal cases as disclosed in the communication dated 30th June 2026, this court is not inclined to pass on order as prayed for. Stop. Writ petition stands dismissed. Parties urgent xerox certificate copy.
Grateful.
It should have been dismissed with cost because there is a suppression of material fact.
Item number 88. But that gives a good ground for appeal. I generally do not pray for cost.
No, otherwise it's the abuse of process.
Abuse of process. Unnecessarily.
Yes.
This is docket.
And for the petitioner, a report has been called for my
Report is here, Lordship. FIR was drawn up basis the complaint of the petitioner. Charge sheet has been submitted against.
My lord, that was in 2025, my lord.
Yes.
The petitioner and her husband both are senior citizen. The petitioner is aged about 71 years. Her husband.
So already English Bazar police station case started 9/16/2025.
My lord.
Dated 9th May 2025.
I have annexed a copy of the FIR and charge sheet also.
Yes.
That was in last year, my lord, 1 year before. The petitioner and her husband both are senior citizen, my lord. They own a 3-storied building. The private respondents are the owner. They sold out a portion of the building on the second floor to the private respondent in the year 2019, my lord. They are obstructing, creating pressure upon the petitioner by not allowing the petitioner to sell out the entire building so that the petitioner can shift somewhere else, my lord. The petitioner, the private respondents have pasted posters, my lord, which is at page 25.
Then what is the subject matter of previous criminal case being English Bazar PS case number 9/16/2025?
They were assaulted, my lord. The petitioner were assaulted. My lord, the private respondent has installed CCTV cameras with audio facilities, which is capturing the dining space of the petitioner. The movement of the petitioner has been restricted. They are not allowed to enter the rooftop, my lord. The private.
Now, based on previous complaint, a case started.
That is pending, my
Now,
lord.
subsequent complaint you have
May
prayed for
2026,
has been on the basis of the representation dated 16 January 2026 to take steps. If steps are not taken, then what are the remedy available to you? Remedies available to you?
My lord, I am praying for a protection to the petitioner.
No, that is not the prayer.
My lord, I have.
My lord, most interesting is prayer
That
C.
ancillary prayer. The main prayer is for taking steps based on the complaint your representation dated 16 January 2026.
My lord, Mandamas, I have prayed for prayer.
Sure.
Prayer C is a little more interesting. She is asking for show cause as to why the petitioner shall not be allowed to sell out her property to some other person.
My lord, kindly.
The police will decide it.
Police will have to
Sir,
become a
for
land
their
broker
property.
now.
Private respondent had demolished my boundary wall, my lord. My lord, I prayed for protection.
By
which is at
presenting
prayer
this
B.
petition, petitioner has prayed for direction upon the concerned police authorities to take based on representation 16 January 2026. We submitted that taking note of such representation dated 16 January 2020. Now, it is submitted that there is inaction on the part of the concerned police authorities in taking steps considering such representation dated 16 January 2026. Stop. Next paragraph, Mr. Das, learned additional government leader representing the state respondents, has filed a communication dated 19 July 2026 of Inspector in Charge, English Bazar Police Station, Malda, and same is taken on record. Stop. Copy of the communication is made over to the learned advocate representing the petitioners. Stop. Petitioner code, single petitioner representing the petitioner. Stop. Next paragraph. It is next. It is disclosed in the said communication dated 19 July 2026 that on the basis of previous complaint of the petitioner, a criminal prosecution being English Bazar Police Station case number 916/2025 dated 6th May 2025 was started under certain provisions of BNS 2023. Stop. On completion of investigation in connection with aforesaid criminal prosecution, a charge sheet being number 889/25 dated 30 June 2025 was filed before the jurisdiction magistrate. Stop. In view of next paragraph, in view of filing of charge sheet far back on 30 June 2025, no further in view of filing of charge sheet dated 30 June 2025, no further order need be passed in English Bazar Police Station case number 916/25 dated 6 May 2025. Stop. Next paragraph. However, if petitioner is aggrieved by the inaction on the part of the concerned police authorities in taking steps based on representation dated 16 January 2026, in that event, petitioner needs to approach jurisdictional magistrate under section 175(3) BNSS 2023. Stop. Stop. In this regard, reliance is placed on the judgment of the Honorable Supreme Court, reported in 2007-6 SSC 171, Aliu Padamsi and others versus Union. Next paragraph. Taking note of availability of alternative remedy, writ petition is not entertained and same stands dismissed. However, this order shall not preclude the petitioner to approach the jurisdiction magistrate in pursuit of it. The parties to act on the third order. Grateful option. Next.
Item number 89.
89, I am for the petition, my lord. 23rd June 2026, there is a direction, my lord, to submit a report regarding the progress of the investigation. My lord, the matter is relating to, my lord, 2/4 deed was executed by impersonated deceased father of the petitioner. My lord, subsequently, we made a complaint to the concerned police station.
Yes.
Lord, there is a 10 accused persons. One accused person get bail from the learned judicial magistrate. Rest of the accused person, no step has been taken by the police authorities.
ভাইয়ের নামটা কি হচ্ছে তোমার নাম? ফারুক ফারুক।
আরে ফারুক নামটা কমন যখন তখন টেস্ট করে নামটা দেওয়াটা ভুল হয়। ঠিক আছে। Thank you. अरे उमर फारूक के accused number 1
FIR is not disclosed. Mr. Das.
Lordship.
Lordship, FIR will find page 37 in my writ petition.
No, in the report.
The reference of the FIR. Lordship, the steps taken in pursuant to the FIR which has been disclosed, that has been
At the top, it is stated.
only that steps have been properly described.
So, 6, 7. 7 accused persons are on bail. Now, specimen signatures have been sent to
There is 10 accused persons.
Director of Fingerprint Bureau, CID Bhavani Bhavan, for a specific but expert opinion not yet received.
Lordship, kindly see
That is
the
the
page
provision.
64.
Now,
of
why
my writ.
the writ court will entertain this?
My lord,
What is the-
more
what is
than
the
2
special
years
case?
elapsed, my lord.
Affecting rights under Article 21.
My lord,
The case of forgery of deeds.
Forgery of
Under
deeds.
section 400, under section 419, 420.
420, 468,
Sure.
464. My lord, two more aspect, Lordship. Lordship, there is a
In terms
direction
of the order
26
dated
January
23rd June
2026, my lord. Lordship, kindly come page 64.
A communication dated 15 July 2026 of Inspector in charge Kumetpur, KUMET, Kumetpur outpost. It is Kumetpur outpost. Under Harishchandrapur Police Station, Malda. Is filed today and same is taken on record. Stop. Copy of the said communication dated 15 July 2026 is made over to the learned advocate representing petitioner. Next paragraph. It is disclosed in the in the aforesaid communication that in Harishchandrapur Police Station case number 171/24 dated 8 March 2024 under certain provisions of IPC under section 41A CRPC, accused persons appeared before the then investigating officer. Stop. Huh? Under section? No. এটা ফুল স্টপ হয়ে গেল ওখানে। পড়ো ভুল হবে নাহলে দেখি। ফুল স্টপ তারপর পড়ো। হ্যাঁ কি বললাম সেকশন accused persons হ্যাঁ নাহলে ভুল হতো কারেকশন লাগতো। Stop. 7 accused persons surrendered before court below and were released on bail. Stop. It is also stated in the communication present investigating officer collected specimen fingerprints of both hands of accused Umar Farooq in presence of learned judicial magistrate second court Chachol and it was forwarded to the to the director fingerprint bureau,
Respondent number 6 here in lordship.
comma CID Bhavani Bhavan for scientific examination. And opinion is, and the report is awaited. Stop. Next paragraph. Taking note of the contents of communication dated 15 July 2026. It appears that certain steps have been taken by the investigating agents.
But it was taken, my lord, indefinite period of time.
Stop. However, stop. If petitioner is dissatisfied with the steps taken by the concerned police authorities in investigating aforesaid criminal prosecution, comma, approach needs to be made within the statutory framework as decided by the Honorable Supreme Court in 2026 SCC Online SC 2020 ঠিকভাবে বুঝতে না পারলে আমায় বলবে 2026 SCC Online SC 798 within bracket Sujal Vishwas Attavar and another versus state of Maharashtra and others. Stop. Next paragraph. Considering availability of alternative remedy, present writ petition is not entertained and same stands. Considering availability of alternative remedy, considering availability of alternative remedy, no further order need to be passed on this writ petition. Stop. Leave is granted to the petitioner to approach jurisdictional magistrate under section 175(3) BNSS if so advised. Parties to act on the server.
Item number 90.
I am for the petitioner, my lord.
My lord, I beg to appear on behalf of state
Last
respondent.
occasion, your lordship has directed to submit a report by the state, my lord.
My lord, here is report.
Yes.
Last occasion, your lordship has directed to submit a report by the state, my lord.
Take it off. Please, what is the matter about?
Matter about regarding that, my lord, kindly come to page 90 of my complaint. That petitioner gave a is an account in Battleground Mobile India game.
Yeah.
Battleground Mobile India. It's a game where I have made an account for play the game. Subsequently, I sold that my account to someone, namely Hitesh, who is residing at Rajasthan, my lord. He purchased the same in the amount of 49,000 from me. Thereafter, after 3 days, his father called me that he sent the amount from his father account. Subsequently, he is threatening me to return back the said amount. I have already returned back the said amount. In spite of that, they are threatening upon me. I have made an complaint.
You registered your name in a gaming app, in a gaming site.
Yes.
Then
Thereafter, the Hitesh Badu, who is residing in Rajasthan, he is asking me to purchase my account. And I sold.
Purchase your account?
Yes. Thereafter, I sold, he purchased the account from me in the rupees of 49,000 from me. Thereafter, he sent the amount.
You sold that account to him?
Yes, my lord. Subsequently, the amount was received by me in my friend's account, 49,000. Thereafter, after 3 days, his father called me and starting threatening me to return back the same. His father.
Of purchaser of
yes,
the,
yes,
of,
yes.
of
Yes.
registration.
Thereafter, I return back the said amount is Annexure 17 and Annexure 18 of my application. And thereafter, I lodge a complaint to the concerned authority. Kindly come to page 90. To
what you are praying for?
To register a complaint and defreezing my account.
Register a complaint.
Complaint and defreezing my account.
So approach the jurisdiction magistrate. What is the use of keeping this
My
matter?
lord, my account was,
What is the use of considering this report?
my lord,
Last occasion, prayer was made on behalf of the state respondents. That's why matter was adjourned.
my account is freezed, my lord.
No, your prayer is for registration of FIR. So if FIR is not registered, then
Another prayer, my lord.
judicial magistrate under section 175.
Yes, my lord.
My
Another,
writ petition will be entertained.
my lord, my account was freezed without any unknown reason. That's why I.
But you now you are praying for registration of FIR since you are threatened by the father of that person.
Yes, that is my one prayer. Another prayer is my account was liened by the bank authority to defreeze same one. Kindly come to prayer C, my lord.
No, your bank account is not freezed. Only it has been marked as lien.
Yes, without unknown reason,
Yes,
my lord.
because the disputed amount needs to be ensured by the bank. If ultimately a decision is taken by the investor authority or the court, then
Oh,
it
my
has
lord,
to
I
be
have
complied
returned
with.
back the same. Kindly come to page 17 and 18.
I could understand that the entire account of the petitioner was debit frozen. That is not the case.
Oh, my lord, entire account is lien. I could not access my account. Kindly come to, I have returned that amount, the disputed amount. Kindly come to page 17 and 18.
Then the bank authority needs to be made party. You have not made bank party.
If your lordship direct me, I can.
No, not at this stage.
Without any direction by the
I will
police
grant
authority,
you
how
leave
can?
to take steps in accordance with law if your account is debit frozen.
My lord,
Where is the
kindly-
case made out in the body of the petition?
Kindly come to pay para 4, 5, and 6, my lord. And also 7, my lord.
Paragraph 4.
4, 5, 6, and
No,
7.
paragraph 4, why you are referring to? Where is the whisper with regard to
My lord, pardon,
freezing of bank account?
pardon me.
Why you are saying submitting this?
5, 6, and 7, my lord. तो पटे बैठ लिखे जिस
No, nowhere it is stated that your account is debit frozen. Where you have stated it? What yes, my lord?
my lord, paragraph 14, my lord.
Is it the way to present the case? Not today. Take it back. File it tomorrow. Come prepared.
My lord, can it be not this week, my lord?
Nothing. Yes, next matter.
Item number 91.
My senior Mr. Keshav Chandra Das engaging code number 35, my lord. That's why I'm praying.
Yes.
My lord, my senior Mr. Keshav Chandra now is engaging code number 35. That's why I'm also praying for not today.
Previous occasion state prayed for time. Very well, not today.
Registration of
Last very he is praying for time. Last occasion on your ground prayer was made for adjournment. That was allowed. Yes. Not today.
Item number 92.
My lord, item number 92, I am for the petitioner laid by Mr. Uday Shankar Chattopadhyay. My lord, here the petitioner is the youth president and assistant president of Trinamool Congress.
Yes.
My lord, here the petitioner is the assistant president and the youth president of the Trinamool Congress of Bhangur 1, my lord, block 1. My lord, on the last occasion, my lord, your lordship was pleased to direct the state to submit a report regarding my lord.
Yes, criminal prosecutions pending.
Don't have it.
Why not? This order was passed on 24th June 2020.
Thereafter, my lord,
Number of criminal prosecutions pending against the petitioner. In matters where you appear, I find that in many cases reports are not available. Why?
Tomorrow I will with instruction.
Yes.
Kindly not to demand. And thereafter,
24th June, today we are on 27th of July, 1 month has passed, and this is not, wait, and this cannot be provided to the court that how many criminal cases are pending against the petitioner. When you are duty bound to upload the particulars of FIR on a website. Show me that you have communicated this to the concerned police authority. Deputy Inspector General Legal is the appropriate authority. Show me that you have communicated it. In many cases, I find that you are not taking steps. For the sake of appearance, please do not appear before this court. It's a responsibility if you represent state. Not in an isolated case, I am expressing my mind. I have seen in many matters communications or reports are not made available or are being filed before this court. Then only option I have to appoint Mr. Das or government period in this matter. For a period of more than 1 month, how many criminal prosecutions are pending against the petitioner? It cannot be provided to the petitioner by filing a report. It is so difficult.
my lord, actually, my lord,
But in other matters, when similar order is passed, learned advocates for the state are filing, placing this report before the one page report is required. Issue. At the time of call, Miss Anita Kundu, learned advocate representing the state respondents, has prayed for accommodation to file report in terms of the order dated 24 June 2026. Stop. Petitioner is represented by learned advocate. Stop. Mr. Das, please take steps in terms of this order. Or court directed far back more than 1 month back to file a report disclosing how many cases are pending.
My lord, I will.
কি বলছিলাম? Stop. Petitioner is represented by learned advocate. Stop. Acceding to the request made on behalf of the state respondents, hearing of this matter stands adjourned. Acceding to the acceding to the request made on behalf of the state respondents, hearing of this matter stands adjourned in order to enable concerned state authority to file report.
Lordship, I have the soft copy of the report. There are 2 cases which are pending.
File it.
I will file.
Here is stop. List the matter under the same heading for further consideration on 5th August 2026.
Item number 93.
93, my lord, I am for the respondent number 5 to 9.
I am for the petitioner in this matter, lordship.
Last petitioner lordship directed the state to file report regarding the development of the case. Blood.
Yes.
She's staying with the private respondent.
Respondent 5.
Yes.
Marriage was solemnized.
Yes.
It has been solemnized and she's a
Crossed. Yes, she's adult.
18
That
years.
is recorded in my previous order.
My submission is that, my lord, my girl is forcibly, my lord, abducted, and they are forcibly, everything is forcible. If the, my lord, let it be 185, 183 of the BNSS has been conducted or not.
Lordship.
164 of the year.
Approach the jurisdictional magistrate.
Everything has been done,
High Court
lordship.
will not enter into this at this stage.
She is adult, my lord. Admit card as I have
Final
submitted.
report has also been filed in the
Final F45.
FRF. Because she has made a statement that she's staying.
Let the report be.
Last occasion, I deposited the marriage certificate and the admit card of the daughter. Love affair. Yes. Yes. Marriage is also. Marriage. The admit card. हाँ ওটা কি কোর্টকে দেওয়া আছে রিপোর্ট দিয়ে দেবে
How kidnapping case stands? Adult lady. Marriage is
Only 18
solemnized.
years. Only 18 years old. My daughter is only, well, in the part, my lord.
The girl has attained majority. How this kidnapping case can be substantiated? Issue.
The concern of the.
You are respondent number 5.
Yes, sir. 5 to 9.
In terms of the order dated 29 June 2026.
They are living happily married life, my lord.
That is what
only my
that is what is submitted on behalf of the state. So no order should be passed by the High Court to hamper their conjugal life.
My lord.
This is your contention.
My lord, directed. Directed to my lord, only prayer my lord, directed to meet once a.
And father is still lamenting. See the situation.
Matters of the heart cannot be gone into.
Having the father my lord, only prayer my lord, directed to meet once a time my lord, anytime.
That is separate thing. Court
Directed to meet
court
once a
cannot
time. I cannot meet my daughter also. That's it my lord.
But that is not the case here.
It's not
That would become an order in terms of the Act 8.
Yes. That is not the case
That
here.
cannot even be done. More so cannot be done in view of the age.
I have recorded in my previous order that they crossed 18 years.
18 years, 4 months.
আচ্ছা, in terms of the কি বলছিলাম, in terms of the 29 June 2026. A communication dated 27 July 2026 of officer in charge Chandrakona Police Station, Paschim Medinipur is filed today and same is taken on record. Copy of state communication dated 27 July 2026. Copies করে দাও. Copies of the said communication dated 27 July 2026 are made over to the learned advocates representing petitioner and respondent numbers 5 to 9. Next paragraph. It is disclosed that final report final report being Chandrakona PS FRMF number 256/26 dated 14 July 2026 was filed in Chandrakona PS police station case number 198 of 2026 dated 25th May 2026. Stop. Next paragraph. In view of filing of final report in aforesaid criminal prosecution, no further order need be passed in this writ petition, and same stands disposed of. Parties to act on the server copy of this order. I am not recording anything. That's
Item number 94.
I am appealing for the private response number 9.
My lord, Lordship, in this matter, I am for the petitioner, Lordship. As per
My lord, for this matter, if the live streaming could be paused, possible.
live stream টা বন্ধ করো. Just a minute. On behalf of the petition.
Faithfully.